But again, this is HOA. If you're just joining us, this is not for condominium certification, HOA, governed by 720. With that said, I want to now turn it over to our co-host from today before we introduce our instructor. This is Heather Gambini over from the fine folks at Hotwire. Great product, by the way, Heather. I've experienced it.
Awesome, that's good to hear. Well, thank you. Good morning, everyone. I hope we're staying warm and cozy on this cold day. Us Floridians are
Layered,
not used to it.
layered, layered, layered.
Very much good. Thanks for being here. So I'm Heather Gambini. Some of you may recognize me from the community management space. I did spend 10 years as a CAM and then decided I needed a new challenge late last year. So I joined the Hotwire team as Director of Community Relations. So what I do essentially is just bridge that gap between properties and what we do. So I'm here to help any CAMs or board members kind of navigate that telecommunications space. So what we do here at Hotwire is specialize in the bulk contracts. We partner with our communities. We provide white glove service, and we bring internet, cable, home phone, and even home automation and security services. So again, thanks for being here. And if you're interested in anything that we might offer here at Hotwire, feel free to connect with me offline and I'd be happy to chat.
And thanks again, Heather. Great to see you again. Always a pleasure working with you.
Likewise.
And before we introduce Alan, I'm going to mention I've got a few things in the Q&A already. If you can see the Q&A, if you can type in the Q&A, if you can hear us, you are signed in. That link you click after you register is your sign in. There's nothing further to do. And yes, it says chat is disabled. Okay. You don't need to go into the Q&A and type, hey, can you see me? Don't need to do that. We know you're here. Don't worry about it. If you can open it, type it, that means you're here. The chat will say disabled for you, but we can send stuff your way. So just click the chat button so it shows up. That's all you need to do. Okay. With that mentioned, I'll mention it one more time a little bit later. Alan Schwartzseid, he is a partner in the firm and the managing attorney over in our Orlando area office in Winter Springs, Florida. Alan, you're in for a treat, folks. Alan Schwartzseid always makes this stuff very interesting. He'll keep you awake, I promise.
All right. Thank you, Jeff. And Heather, thanks for being here. My parents have Hotwire in their community, and I'm very jealous because my community is 12 lots. And, the people will hear today why I made the conscious decision to live in a community that's 12 lots and doesn't really have much governance. But I wish we could work with you guys because you do have a great product. My parents have Vision, and their internet is spot on, and so is their telecom service. I'm very jealous, but they're in South Florida, so I'm not that jealous. Um, I am
Yeah.
happy to be to have moved from there and love the area, but I'm happy to be where I'm at. Jeff, thank you for the introduction. I love that you have that voice for radio. I have a face for radio, is what I'm told, but we'll get through the day regardless. So again, Alan Schwartzseid, I am the managing partner of the Orlando area office for Kaye Bender Rembaum. We are a full service community association only law firm, meaning that is the only group that we really represent. Occasionally, we'll help out members that have election challenges or recall disputes that are getting involved with. But beyond that, we really only represent HOAs, condos, and co-ops, 22 attorneys, 8 board certified in this area of law, including myself, 1 board certified in construction law. So if you've got a recent turnover or your turnover is coming up, and we'll talk about a little bit of that later, or if you just have issues with construction contracts or vendors that aren't doing what they're supposed to do or didn't do what they're supposed to do, those are all things that we handle, including the collection, covenant enforcement amendments, the day-to-day, etc. So if you're happy with your current counsel, good for you. Very happy for you. Thanks for showing up anyway. If you're not happy with who you're working with, as long as that's not already us, or if you are just not sure who you're working with, that means from my perspective, they're not communicative enough. Feel free to reach out. My email address is going to be on the slides that we will show in just a moment. And now I am remembering that I need to actually populate those. So,
Well, and while you're doing that, I'll mention one more time since a few more have joined.
sure.
If you are here watching in a group, be sure you are signed in as well with your own individual link. And when I say signed in, that just means you clicked the link you got when you registered. Doesn't mean you have to do any signing in right now. It just means that when you register, you get a link from Zoom. You click that link to come in and open up this interface that you're on right now. You're good to go. But if you haven't done that and you're watching with other people and haven't used your own link, be sure you use your own link if you want to get credit today. That's hopefully I made that clear. And lastly, as Alan's pulling up the slides, remember today is educational in nature. None of this should be considered as legal advice, even if it sounds like legal advice. This is for the informational, educational purposes only. Alan, back to you.
All right, so I will go ahead and share that screen. And thank you again to Heather and Jeff, of course. Thanks for your help as always. It's always good to partner with people that you respect, that you trust, and Heather and Hotwire definitely fit that bill for me. So again, if you need to contact me or if you just want to contact me, my email address is right here on the screen. as@kbrlegal.com is the easiest way to reach me. If you actually like what you hear, hopefully that'll be the case. Feel free to follow me on LinkedIn as well. I do try to make sure that a couple times a week I post something that's helpful for community association managers, for the board, etc. So moving into the actual materials, why are we actually here? Well, within 90 days after being elected or appointed to the board, every newly appointed or elected director must take this class. Doesn't have to be with us, but you made the right choice. Complete this curriculum and get the certificate that Jeff mentioned earlier. You will not get that until after the class and after you fill out your survey. So understand you are not going to have that right now. You also don't need to be writing down every single thing I say, just so you're aware, because you will get a copy of the materials along with these the certificate after you're done here. Now that certificate needs to go to your secretary, or if you have a management firm, usually that's the person or the group that will maintain your official record, so it goes to them. Now in an HOA, the certificate's good for up to 4 years, or as long as you were on the board consecutively. Now, if you come off the board at any time, not that you've been suspended, but you've actually resigned or been removed from the board, then you'll have to retake this class if you jump back on. So it's up to 4 years. You do need to take this class every 4 years, and there are certain educational curriculum that are involved today, so I won't go through what they are, but they are things that need to be discussed in this class in order for you to get your certificate. Trust me, you will get it, and it will be valid, so long as you follow what Jeff has told you earlier. Now, if you do not have this done within the 90 days after being elected, technically you are suspended from the board. This does not mean that the board members have to actually make a decision to suspend you. It means automatically, by virtue of statute, you're off temporarily until you've completed this requirement and your certificate is placed in the official records of the association. So everyone that's here today presumably is doing the right thing, but let the other directors in your community know that if they don't do this within those 90 days, they will be off the board whether you want them to or not. Doesn't matter. They're just off. The board can temporarily fill that vacancy. For example, if someone says, I'm not doing that education, it's garbage. I don't care about knowing what I'm supposed to do in a corporate position, which I think would be foolish, but I have heard. It's not my responsibility, yes it is, to know everything I'm supposed to know. So if people are saying I refuse, then you might want to fill that vacancy because that person that's refusing to take the class is not coming back on the board until the next election happens, and chances are they're not going to be reelected anyway. You do need to keep the educational certificate for inspection by the members for 5 years after the election. Why you need to retake it every 4, but keep it for 5, I don't know. That's the legislature doing its thing. Failure to have this written certification in the official records doesn't affect the validity of any board action. So if you weren't aware that this person didn't take the class, which, by the way, now that you know you have to take it, you really should be looking to see who did and didn't take it already. But if you didn't know, it's kind of a no harm, no foul type of situation. So the board decisions that were made while that person shouldn't have been on the board because they should have been suspended are still valid. Now, there is also a written certification that needs to happen in addition to this educational class. That's something that your manager should be able to help you with. If not, you're going to want to contact your attorney in order for them to help you just get a form. Frankly, if you Google HOA board member certificate, you can probably find one fairly easily. There is also a continuing education requirement for HOA board members. If you have fewer than 2,500 lots in your community, You should know how many lots are in your community if you're on the board, by the way. If you don't, that might be step one once you get out of this class. So that's something to write down. But you will need at least 4 hours of continuing education annually. Now, this requirement has been in place since July 1st of last year, and the state government has not authorized anyone to actually teach the classes to get these 4 to 8 hours. So just understand you have an obligation to do it, but there's no way to do it yet. Now, this is being recorded in January 21st, 2025. Depending on when you're watching this, that may no longer be accurate. I hope that that'll change very soon because everyone only has until the end of June to get this done. But anyway, a director of an association with 2,500 lots or more needs to get 8 hours of continuing education. Apparently, the legislature thinks you need more education, even though you're generally performing the same tasks just because your community is larger. So that's how it works. All right, the statutes, what are we actually talking about here? I'm not going to go in depth on any of these. These are just some differences between condos and HOAs. We will get into some of this later. None of it is absolutely crucial, and I'd rather make sure to keep some time for Q&A at the end of the class. So we're just going to kind of move on. But you do have these slides here for when you get the materials. It's probably worth at least reading through because a lot of people don't understand that just because you're in a condo and it's an association doesn't mean it's an HOA. So I hear a lot of people calling a co-op an HOA, a condo an HOA. That is understood by some people, but legally inaccurate. And if you call it an HOA, you might be looking at the wrong set of statutes. Chapter 720 is the one that's going to govern an HOA. Chapter 720 does not apply to, and we'll go to number 3 here, a Chapter 718 condo, a 719 co-op, a 721 mobile home park, except to the extent, 721 is timeshares, except to the extent that a provision of those statutes expressly incorporates 720 or is incorporated into 720. I don't know that there really are many of those, if any. It also doesn't apply to commercial, industrial, or other non-residential communities. So understand you might be governed by a completely separate set of statutes, even though you're an HOA. If you are primarily commercial, you are not governed by 720. Likewise, the commercial or industrial lots or tracts or parcels in a community that has residential primarily is still not going to be subjected to 720. So if you've got, let's say, an HOA that includes, for example, a restaurant, okay, that commercial parcel might not be subject to Chapter 720. It would be governed by the profit or not-for-profit statutes. So those are different things to look at. But again, 720 is really what's going to govern the rights in a non-commercial, non-industrial HOA. Then the question becomes which version of Chapter 720 of the Florida statutes actually applies to your community. Now, it's kind of contract law 101 that whatever statute was in place when you enter a contract is grafted into that law, that contract. That year's statutes, the substantive statutes that were in effect as of the date of the contract, which is when the contract is signed, is going to take effect and continue throughout the life of that contract unless the parties agree otherwise. The contract we're talking about here is your declaration. Okay, a declaration of covenants, conditions, and restrictions. Some people call it the CCRs, CCNRs. It might include the word easements or something else, but the bottom line is what we're talking about is your declaration. That is the constitution of your HOA. And so the Constitution is pretty important in case you're not that aware of how the law works. The Florida Constitution is very important. The U.S. Constitution is very important. They are the bedrock documents that we base everything on in the state and in the country, or at least we're supposed to. So constitutional due process rights say that the legislature, being an arm of the government, can't take away substantive rights that the parties already had. What does this mean? Unless your contract says, hey, the legislature can change whatever they want and that will apply no matter what the change is, even if we don't like it. Unless your governing documents say that, which is this Kaufman language, generally only procedural changes to a statute will apply to the association. Now, what is substantive versus procedural? Even experts in this field disagree constantly. There's an email chain going back and forth literally as of yesterday as to what is substantive versus procedural on the, I'll call it the nerd forum, but really what it's called is the Condomania email listserv, which is a list of about 700 Florida Community Association attorneys. Now, this Kaufman language that I mentioned is basically incorporating language in your governing documents that apply the Florida statutes or Chapter 720 as amended from time to time. That as amended from time to time that's bolded here is the most important language for this purpose, because what that's going to say is, I don't care what changes in the statutes, they're going to apply. Now, you may have that language with respect to a specific item like fines. It needs to be as to everything in order for all statutes to apply throughout the community. Now, I won't go into too much detail about this, but it is important to mention, you can't just look at the statute and presume that it controls over everything, because you might be looking at the wrong statute, or your governing documents might in fact control over all of it. So we've got some examples of procedural versus substantive rights here. Substantive rights are, there is an ownership interest in this thing. It may not be a physical thing. It could be your voting rights, for example. Procedural laws are, well, this is how you do it, and it's different. So one good example is a cause of action, borrowing from this Woodside versus Jaron case. There are vested rights in the declaration involving configuration and size of a lot, ownership shares in the common expenses and surplus, and appurtenances to the lot. Now, this was a condo case, but I anticipate, and so does every other attorney in Florida, I presume, that knows anything about this area of law, that it would be applied equally to an HOA and to lots instead of units. So that's why we have that parenthetical here in some of these bullet points. Now, Chapter 617 is one that even a lot of attorneys don't realize applies to an HOA. This is the not-for-profit statute of the Florida statutes. If there's a conflict between these two statutes, and I mean an actual conflict, not just, well, here's one way to do it, here's another, then Chapter 720 will govern your community, period. But there are things in 617 that are different, that sound like conflicts. So this is one you're going to want to run by your attorney. Frankly, anytime you're interpreting a statute, you're going to want to run it by your attorney. It's not something that I recommend because this is so procedurally strict in HOA world, and less so than in condo world, but still very procedurally based. You're going to want to run most things by your attorney if you can. Now, we mentioned conflicts between these two statutes. There's also potential conflicts, and they may or may not be real conflicts, but when there's a real one between the governing documents, here's the order right here. Okay, and remember the old expression, a little dab, D-A-B, will do you. The declaration comes first. As I mentioned, that's your constitution of your community. And judges are going to look at that document and presume that everything is valid in it, because generally the members get to vote on what goes in that document. And it's just kind of presumed, well, you know, if it was in here when we bought in, or there was a risk that it would be put in later, then everyone should have been on notice, and, you know, you're kind of stuck with it. There are certain things, for example, fair housing violations. So if your declaration says no Jews or Black people can live in this community, yeah, chances are that's not going to be enforceable. And there are statutes now that say that those types of provisions can be removed by the board, even if the declaration requires a member vote. But generally speaking, the members are going to get to vote on what goes in here. Judges presume that it's valid unless there's case law that says you can't put that in your declaration. The articles of incorporation are generally going to be, and by the way, I'm sorry, let me step back to the declaration. That's going to be your document that governs how you use the community and what needs to be done within the community. The articles of incorporation are the document that creates the corporation that runs the community. So when you're on the board, I mentioned you're running a business. You are a volunteer director of a not-for-profit corporation if you are on the board. If you are an officer, the president, secretary, treasurer, VP, you are an officer of a corporation. So keep in mind, when I say the articles of incorporation, that's the document that created the company you're running. So just remember that. It'll say what the purpose of the community is, or what the purpose of the corporation is. It'll basically outline what your initial address is supposed to be, who the initial officers are. Frankly, there's not a ton that the association uses those articles for on a day-to-day basis. The bylaws are generally going to be your operating item. So how are the directors appointed? Who can they be? Who are the officers? How are they appointed? And when I say appointed, I mean appointed or elected as to both of those, depending on your procedures. How is your community going to be run is really what the bylaws are going to handle. And again, because the members generally get to vote on this, it's probably going to be something that it's going to be okay, whatever is in there, unless it's illegal. Now, there are statutes that will override some of the things that are in these documents. You may have rules and regulations, architectural criteria, procedures, and policies, all of those things that get decided by the board. Those are generally going to be scrutinized very highly by a judge because they're really things that the board can decide from day to day, really, if they want. Now, you have to actually update the document, but at any board meeting where that item's on the agenda, and it may require larger notice than just the standard 2 business days or 48 hours, but you can really make any changes you want to these things as long as it's not in conflict with these higher documents. So going back to the original point, it goes in order: declaration, articles, bylaws, rules, etc. If there's any conflict, the higher document on that list is going to control. Membership meetings is our next topic. So you have a couple different types of member meetings. One is the annual meeting. This is really where your election is going to be held. And when we say it's when your election is going to be held, it needs to be held at or in conjunction with the annual meeting in accordance with the governing documents. Usually that's the bylaws. Again, that's your procedural document. But when we say in conjunction with, that doesn't mean it has to be held during the annual meeting. We'll get into elections in a little bit, but understand, a lot of people say, well, it's the election meeting. Okay, what about the annual? Because those two aren't necessarily the same meeting, even though 99% of the time that's how they're held. You do have to have at least one meeting each year at a time, date, and place stated in or fixed in accordance with the bylaws. What I see in a lot of sets of bylaws is it needs to be on the 3rd Thursday of this month every year at this time. Why? Why be that specific and basically force the association to screw it up most of the time because that time wasn't available at the preferred location? So my suggestion is have it be fairly vague. Yeah, okay, you want to include a time of day, that's fine, but have it be within a period of 2 months that the association can hold that meeting so that you're not compromised if that one time and that one date and that location is suddenly not available when you're required to have your meeting. So that's one amendment to the bylaws that you might want to consider if your bylaws are set up that way. Now, any other member meeting is going to be a special meeting. That's just literally any meeting other than the annual. And that's going to be held either when the board wants to hold one to address any issue. That might be to address amendments and not at the annual meeting. It might be to address some kind of reserve vote, which we'll address later. But that's anything other than the annual meeting. That's going to be held when at least 10% of the voting interest petition for it. Now, I've had a couple things come up recently where someone wrote and said, I've got 10% of the members with me and they signed a petition. My response is, that's great. Where's the petition? Because saying you've got 10% of the votes doesn't mean anything with respect to scheduling this special meeting. So make sure that if someone is saying, well, we're requiring a special meeting as members of the association, that you actually have the petition and you've reviewed whether the signatures are valid, whether they're actual members of the community and entitled to vote. That might be something that you want to bring up with your attorney as to, okay, well, do we really need to have this meeting? And then you can decide as a board whether you want to review those ballots or you want the attorney to review them. There needs to be an agenda for every meeting in an HOA except the annual meeting. Now, an agenda is basically a list of what you plan to address during that meeting. It goes along with the meeting notice most of the time, but essentially you'll want to have one, in my opinion, even though you don't have to have one for the annual meeting. Here's why. Members get to discuss whatever is on the agenda, but you can limit them to what's on the agenda at that meeting. If you've got a bunch of members that are complaining about X, Y, Z, but that's not on the agenda, sorry, we aren't scheduled to discuss that today. Okay. Now, obviously, you want to be transparent. You want to have the members' voices heard, and we'll get into how to do that in a little bit. But you don't want to make it a free-for-all so that you can't do the business of the association at these meetings. So consider having an agenda at the annual meeting, even though you don't have to. And then, frankly, the other benefit is you don't have to remember which meeting you're supposed to not have an agenda for. You just have it as a matter of course for every single meeting of the board, every single meeting of the members. Special member meetings, you do need a specific description of the purpose for the meeting, and you can only address the business that is scheduled to be discussed during that meeting. Now, the notice of the meeting, this is again member meetings only, needs to have the time, date, and location of the meeting so that people can actually show up. Kind of makes sense. Now, if the bylaws don't provide for a separate way of giving notice to the members, the association needs to mail, deliver, or electronically transmit notice to the owners at least 14 days before the meeting. When I say electronically transmit notice, that means basically email or fax, but it only applies to people who have opted into receiving notices that way. If you're just email blasting all of your meeting notices, you are not doing it right unless 100% of your community has opted into receiving email notices. I think it's a great idea for them to do that, but you can't force anyone to opt in. So keep in mind, if you don't have something in writing, whether that's electronic or otherwise, stating that each person opted in to receiving emailed notices or electronic notices, you need to still mail out that notice. You also need an affidavit confirming that that notice went out, and whoever sent it should be the one that signs the affidavit. It should also include a mailing list of everyone that that notice was sent to and a copy of the notice itself so that you have proof that goes into the official records of the association that that notice was sent. Now, it needs to be mailed or delivered to the address identified as the mailing address in the official records. What does this mean? You are not obligated to go out and seek out other addresses for the owner. If they don't get it because they didn't tell you, they don't live in the community, and they never gave you a mailing address, that is on them for not getting it. If they did provide you that mailing address, you have a legal obligation to use it. So just make sure that your records are updated. You should be keeping a roster of every member of your community who owns which lots and what their mailing addresses are and what the lot information is. Now, we discussed some of this electronic notice requirements. It's basically you need to have people opt in before you start using it. It can't be used as a method of calling a meeting for a special meeting for a recall. So a recall is basically trying to pull people off the board regardless of whether there's a reason to or not. That's the one reason or the one type of meeting that you can't use electronic notices for in an HOA, even if people have opted in. Broadcast notice is another option. I don't know of anyone that does it unless they're in a huge community, and in that case, their manager should be working with their attorney to do it correctly. If you have 100 or more lots in your community, then by January 1st of this year, you are supposed to have an association website. If you're working with a management firm, most of the time, the management portal will function as that website with a couple additions here and there. So if you're working with a management firm and you don't know if you have a website, but you have 100 lots or more in your community, it's time to reach out to them today because you're already out of compliance with this requirement unless they voluntarily just decided unilaterally to take care of it for you. Now, when it comes to what we're talking about, these notices, all of the notices need to be posted in addition to being mailed at least 14 days before the meeting. The agenda needs to be posted on the website at least 7 days before the meeting, along with any documents that will be considered during the meeting. So that could be a representation agreement for a new attorney you might want to work with, or whatever other documents the board is considering or the members are considering during that meeting. The other thing to keep in mind is that, where is it? Is it here? Yeah. This bullet point, and hopefully you can see what I'm highlighting. Of course you can. There we go. It needs to be in plain view on the website or under a separate notices tab on the front page of your website. So make sure that you are at least putting that up there. For all upcoming meetings, you should have at least a notices page with a link directly on the front page of your association website if you're required to have one. If you're not required to have one, frankly, do whatever the heck you want on that website. Jeff, you had a comment?
Yeah, it's slightly unrelated, but I'm getting a lot of questions here now. I don't want the Q&A bogged down. Folks, Alan mentioned a little bit earlier about continuing education for board members. Okay. This is a certification class. This class does not count towards board member continuing education. What Alan mentioned earlier is that we nor any other provider has yet to receive direction from the division on the board member continuing education. If you took a board, and a lot of you have also mentioned you took a board certification class already, do I need to retake this? And the way we understand it now, and Alan, jump in if I'm incorrect, but what you mentioned earlier is that if you took a board member, an HOA board member certification, or even a condo one for that matter, if you're in a condo, if you took one before July 1st of 2024, you still need to take this one as a recertification, so to speak, by June 30th of 2025. Okay. So I hope that clears things up for everybody. There were a bunch of those comments in the Q&A, and I'm hoping that makes sense for all. Alan, back to you.
All right. Right to participate. So I mentioned this a minute ago, and this is item number 1 that I think you should have a written board policy governing how this happens and how it goes. There's going to be 7 or 8 of those policies that I'm going to recommend throughout today. But owners have the right to attend all meetings and to speak at any meeting with regard to any item open for discussion or anything on the agenda. This is why you want to stick to your agenda, because otherwise you're opening it up for discussion. And what that means from a practical standpoint is that every member of the every member of the community is allowed to speak on any item for at least 3 minutes. If you don't have that in your rules and regulations, I've heard some people argue, and I don't necessarily agree, but that anyone can speak, frankly, for as long as they want. I don't like that idea. You want to get your work done. You want this meeting to last like a half hour, not 5 hours. So my recommendation, make sure you adopt a policy. And this is the written reasonable rules that we're talking about in the middle bullet point here, governing the frequency, duration, and other manner of owner statements, which can be to say they need to sign up in advance in order to be allowed to speak at the meeting. So keep in mind, you don't have to let everyone in the world speak. You just have to give them the opportunity. If they choose not to avail themselves of the opportunity to write in advance, then they might lose the ability to speak at that meeting. However, that requires a written procedure that is adopted by the board that we can prepare for your association. I do have some communities that hire us just to review the governing documents, compile them all, OCR them, and get them back to you with bookmarks and prepare some of these policies. And that's all they ever need. And that's okay if that's what the board is looking for. But I do think that these are important policies to have, because you might not have a problem with a member that won't shut up now, but I promise at some point that person's going to pop up. Now, another important thing, because I had this question literally last night from a client: an owner may tape record or videotape membership meetings, period. Full stop. No chance to say no. Now, you can adopt rules governing the taping of meetings. In other words, this person can't run around with their cell phone in the face of every person that chooses to speak. They can't interfere with the meeting. But you need to adopt rules, in my opinion, that will govern that issue before you just say, sorry, you can't videotape anymore, because they have an absolute right. Moving on, unless a lower quorum is provided by the bylaws, 30% of the voting interests of the association is a quorum, which is what's required when people say a quorum. That's what's required to even have a meeting. If you don't have a quorum, you don't have a meeting, period. And unless the governing documents say otherwise, a majority of the voting interests present in person or by proxy at a meeting at which a quorum has been attained is a decision-making group. So it's not necessarily a majority of the community. It's a majority of the people that show up, as long as you have a quorum, and they can show up either in person or by saying, I have proxy for someone else. Now, proxies must be dated. They need to include the date, time, and place of the meeting for which they were given, and they need to be signed by the person who executed the proxy. If any of these things doesn't happen, that proxy is not valid, meaning that it can't be used for voting purposes or for quorum purposes. It's valid only for the specific meeting for which it was created. So if you've got a proxy from last year, that doesn't mean that that person that was the proxy holder gets to vote at this year's election, because it's only valid for 90 days and for that specific meeting. Okay. They're revocable at any time by the person who signs. Any proxy holder can appoint someone to substitute for them. Let's say I gave my vote to John via a limited proxy. John can't make it to the meeting last minute. He had an accident with his car, hopefully, and not anything else. But regardless, you know, I'm going to have John, Jim, I think was the name, whoever it was, is going to give this proxy to somebody else. Okay, the original proxy can be used or a copy can be used as long as it's a complete reproduction. So you don't have to have the original proxy in hand in order to be able to use it. But look out for people who copy proxies and then submit 5 of the same one. So you want to make sure that you're taking your roster and checking off who's already voted and who hasn't. General versus limited. General says vote however you want. Limited says here's how you can cast a vote for me. Both limited and general can be used to establish a quorum. There are certain things where only limited proxies can be used for certain votes. Electronic voting is not something we have the time to get into detail about, but I do think it's a good idea to look into, especially if you're having trouble getting people in the door to actually show up to a meeting where the members get to vote. The reason for that is electronic voting allows people to click through something on their cell phone and be done. They don't have to show up to a meeting. They don't have to click a Zoom link. They don't have to go on camera. They don't have to wait for someone else to show up. They click once they get their email and their vote is tabulated. It's done. You do need a board resolution at least 14 days before the meeting when you're first going to be using that electronic voting medium. We do have a bunch of vendors that we work with fairly regularly with respect to electronic voting. So even if you choose not to work with our firm, which I think would be a mistake, but is your call, I'm happy to give you some contacts that you might be able to reach out to and see if they can help you with your electronic voting and get some more people involved in the vote in your community. That will make it more likely that if you have amendments that you're trying to pass or whatever you're trying to do, or you're trying to actually hold your election, that you're able to do it. Now, this is another thing where the members must opt in order to be able to use it. So keep in mind, it's not just, well, we adopted electronic voting, now everyone can vote electronically. They have to actually sign something, and that can now be done electronically in and of itself. So we'll skip the rest of electronic voting and move on to elections. And yes,
Alan,
I'm
real
speaking.
quick,
Yeah,
we just got a couple questions on quorum, so because we have a few, I wanted to get those answered.
sure.
Um, so the question is, our docs say 2 board members makes a quorum. Is that allowable?
Can you repeat the question?
Our documents say 2 board members makes a quorum.
So that's a quorum for a board meeting. And we're talking about a member meeting. So it's a separate issue. Keep in mind, if you have 2 board members at a member meeting, that means you have 2 members. So that brings up a good point, Heather, and we can go through. So the shorter answer is no, that's not a quorum for a member meeting. Yes, it's a quorum for a board meeting if that's what your bylaws say. But we haven't really gone through who's who and who does what in an HOA. So you've got 3 different positions that people might be in as a member of the board. You've got the members. I've used that term a bunch, but I haven't explained what it is. It's literally someone who owns a lot, period. Easy enough. So the members are the people that own lots. Usually they're the people that are going to get a vote at a member meeting. At a board meeting, only the board votes. So that's why that quorum of 2 directors, 2 board members, is a quorum at a board meeting. You've also got your officers. Those are the people that have specific tasks that are outlined both in the statutes and in your bylaws. That's your president, who's generally going to be the mouthpiece, sign the documents, etc. You've got your vice president, who doesn't really do anything, but is available if the president's not. You've got your treasurer, who's supposed to be managing the money. If you've got a CAM, they're probably doing that, which is a community association manager. And then you've got your secretary, who maintains the books, the records, etc. That person is generally going to also be superseded by your manager if you have one. Finally, you've got your directors. Those are the members of the board, and they literally only have a few jobs. Okay, I think it's literally 3. They make motions, second motions, and vote on motions. That's all a director does. They are the board. They make the decisions for the association that the members don't get to decide. And frankly, because this is a business and the shareholders of a business don't get to make most of the decisions for the business, that's the board's job. The board of an HOA does the same thing. They're going to make most of the decisions, probably more than 75% of the decisions that need to be made for the association overall, other than the election and amendments. Those are really the only two things in most communities that the members ever really vote on. So keep in mind, yes, great question, but we're talking about a quorum at a member meeting right now. We'll get into board meetings in a moment. So electing directors happens at or in conjunction with your annual meeting. Unless you've got term limits in your bylaws, generally speaking, that term expires every year. They need to be conducted in accordance with the procedures set forth in the governing documents. What does this mean? Follow the bylaws when you're having your election. That's pretty much the entire statute, is follow your bylaws with respect to elections. Unless the governing documents say otherwise, you do need a quorum at the election in order to have an election meeting and in order to conduct any other business at that annual meeting. A majority of the plurality of votes cast here means whoever gets the most votes wins the election. Anyone is eligible to serve on the board unless otherwise disqualified, except there are a couple exceptions here. Someone who owes money to the association on the last day they can nominate themselves to be on the board cannot seek election to the board or be listed on the ballot. Now, if you've got nominations from the floor being permitted in your election meeting, that means that as of the date of the election, this person could pay that bill, 20 minutes before the election meeting and be allowed to nominate themselves from the floor. So don't think that just because you're in an HOA and you think that there are no nominations from the floor, that that's necessarily the case. It might be something you need your attorney to evaluate what's in your bylaws to confirm. The next category, someone who's been convicted of a felony in Florida or in another district or U.S. territory that would be a felony in Florida and has not had their civil rights restored, meaning they've been out of prison for at least 5 years on the date they seek election, is not eligible to serve. Someone who's got criminal charges pending for, and this is just a list of things, directly related to HOA or condo operations, is also not eligible to serve on the board. A member can nominate themselves or anyone else that is a member of the community, or depending on your governing documents, you might not have to be a member of the community to serve on the board. However, if the election process allows candidates to be nominated in advance of the meeting, there should be no nominations at the meeting. What does this mean? If you have a ballot already created and mailed out that everyone gets to vote and mail back their ballot, it's not fair to the people who would be nominated from the floor that they have all these people that think that they voted for everyone that's going to be on the ballot, and they're not even showing up to potentially change their vote and vote for these people that say during the meeting, hey, I want to be on the board. So keep in mind, you really need to decide in advance, and preferably in your bylaws, whether nominations from the floor of the election meeting are allowed. Now, on election day, if you do not have enough people to fill all of the spots plus one that are available on the board right now. So let's say you've got a 5-member board. Everyone is up for re-election this year. You have your election and 5 people, frankly, the same 5 people who are already on the board probably, are the only ones even during the election that say they're interested in serving on the board. You do not need an election. Those people are on by acclamation. They've decided, and you've decided for them by not self-nominating, that they're the only ones that were nominated, and you don't need an election to decide that the 5 people that were nominated are the 5 people that get the spots. It's only if you have more people that are trying to be on the board than the people that fit on the board that you actually need an election on election day. Members can vote in person or by proxy at the election unless the governing documents say otherwise. If you're allowed to vote by secret absentee ballot, the ballot gets placed in an inner envelope with no markings. That's to maintain confidentiality, and mailed or delivered to the association in a separate envelope that does contain markings so that the association can verify whether or not that person is eligible to vote and whether they already voted. If you've got more than one ballot inside an envelope and that lot owner doesn't own more than one lot, those votes are invalid. Okay, you mark them as discarded. You could mark the reason they were discarded. That's up to you, but you're not going to count them. If someone votes for more individuals than there are open slots, that's going to be discarded as well. If someone votes for less individuals, then there are open slots, meaning that there are 5 open directorship roles and they only voted for 3 people. That's fine. It's totally okay. What I would also suggest is if someone does write personal information, identifying information on that inner envelope, be inclusive. Okay, well, they did it wrong, but all they've done is waive their right to confidentiality during this secret balloting process. Okay. Unless the bylaws provide otherwise, again, directors serve a 1-year term. Any election challenge needs to be brought within 60 days after the election results are announced. You cannot challenge last year's election in 2026. Sorry. Any dispute is going to be submitted to binding arbitration or to litigation. So the association or whoever is raising that gets to decide how to proceed. Officers are generally going to be appointed by the board. So you have the annual election, you decide who's on the board, and usually immediately following that, you will have a separate board meeting called an organizational meeting. I make that distinction very clear because a lot of people do not set up a separate board meeting, which means that they are doing it wrong, and they've never had a formal, proper board meeting to decide who the officers are. So they need to ratify the decision later on. Do this the right way. Schedule this organizational meeting, and you don't even have to put a time. Just put immediately following the annual meeting, and that's enough. Okay, it'll be in the same location as the annual meeting, and you can even put it on the same notice, frankly. You're just going to make sure that it's clear that it is a separate board meeting, whereas the annual meeting is the member meeting. And the directors just decide who's going to be who. There's no prohibition against changing officers midterm. So I've had some presidents go rogue and just decide that they can do whatever they want because they're the president of this HOA. And they're going to send demand letters to people without consulting with the rest of the board on behalf of the association, put it on association letterhead, sign off, or they're going to go to someone's house and knock on the door and say, hey, I saw you're in violation. You need to fix that right now or the association's coming after you. Well, the board didn't decide that. So if you've got a rogue officer, or if you've got a treasurer who you're concerned is stealing money, a secretary who's not maintaining records, whatever reason, or you just don't like them, frankly, there doesn't need to be a specific reason. The rest of the board can vote to replace that officer position with someone else. Directors also can't vote by proxy or secret ballot at board meetings because it has to be open, except that secret ballots can be used in electing officers, just like electing the members of the board. Okay, there's a lot of fraudulent election voting activities that have popped up. Basically, don't do anything to try and force someone to vote in one way. Don't change balloting. Don't menace, threaten, or use bribery. Don't aid in the perpetration of a fraud in connection with a vote cast or attempted to be cast. All of these things are a first-degree misdemeanor in Florida. So basically, if you can't figure out what election fraud is and you're worried that you might be doing it, maybe don't do that thing. Okay, we'll move on. There are new laws. We talked about first-degree misdemeanor. I know that I'm being a little bit cavalier when it comes to a crime, but the bottom line is if you can't figure out what it is, either run it by the attorney and find out whether it's allowed, or run it by your own attorney who is well-versed in this area of law and who can guide you properly through that process, or just don't do the thing.
Alan, we've got a couple questions sort of related to that. So the first one is, what does a pending criminal charge mean? So emphasis on pending.
Pending means that there's actually a criminal charge that's been brought against the individual and there are criminal law terms that are used, but it's information or indictment are the criminal law terms. Basically, a prosecutor decided that there's enough evidence to support a claim that you did whatever you're accused of doing, and that hasn't been dismissed at that stage. So it doesn't mean that there's a lawsuit that's been filed, but it means that charges have been brought. So, criminal charges are pending means that they haven't been dismissed and they've been brought against you. I don't know how I can be clearer than that, even though I recognize that that might not be clear enough for some people. You might want to consult with a criminal attorney on that one, but the bottom line is if you have pending criminal charges related to association business, you're not going to be able to serve on the board. And if frankly, if you're not sure whether you've got those types of charges pending, or you're not sure whether the types of charges you've got pending are these types of charges, maybe you should rethink service on the board and take care of that criminal charge before you worried about your community.
Great advice. Thanks, Alan. The next one is, are board member nominees legally obligated to go through a background check prior to joining the board?
If the association has a policy of requiring that, then the answer is yes. Generally speaking, there's nothing in Florida law that requires it. But if your particular community has something in writing, not just, well, we want everyone to do it, but if there is something in writing, generally it's going to be some kind of written policy adopted by the board that says anyone that wants to be a nominee has to do this. I'd prefer to see it in the bylaws if you're going to require it, because then it's less subject to challenge. But yeah, generally that's going to be enforceable if you've got something that says you need to do it. Now, if you've got the current board just coming to people and saying, well, we want everyone that wants to be nominated to do this, so we're going to put it in the election packet this year, I don't think that's good enough. All right. When vacancies pop up, you fill them either by another election, and my answer to that is, why the heck would we go through this process again? Or preferably, you fill it by appointment. Appointment is basically the remaining directors decide who they want on the board. They have a vote at an open meeting or via a written resolution that's signed by all of the directors. That's another 617 not-for-profit statute tip here. But that is a written consent is what it's called in the statute. It's really a unanimous resolution of the directors. But you can just fill the spot. Why would you have an election when you can just fill the spot? It's a waste of time and money, in my opinion, unless you can't find someone willing to do it, in which case you're wasting even more time and money. So moving on, unless the bylaws say otherwise, the director serves for the rest of the vacancy. So, pardon me, you've got an election in January. In June, someone drops off the board. They decide that they need to take care of personal stuff and they can't be on the board anymore. You fill that vacancy, and until the following January, that person stays on the board. Then they're up for re-election. Now, I say until January. If you've got staggered terms, that term of that spot, that director position, might be longer. This is one you'll want to run by your attorney to make sure you're doing it right. Okay, the board. Board voting and decisions need to be done within an open board meeting with very limited exceptions. The officers and directors, this might be the most important thing you hear all day. So if you've been going out and getting a drink or running the restroom, this is the time to put it down and listen. Officers and directors of an association have a fiduciary responsibility to the owners. What does that mean? You've got a legal obligation to do what is right for the association, for the corporation itself, even if it hurts you, if you are an officer, director, or a manager. Okay, you need to act reasonably. There's a thing called the reasonable business judgment rule. You are allowed to make bad decisions as a director if you could reasonably have thought they were in the best interest of the association. Now, keep in mind, if you got legal advice that says this is a bad idea, here are the risks you're taking, and you did the bad thing anyway, that business judgment rule will not protect you. Okay. That's why a lot of times some clients will ask me for a written opinion that says that doing what someone is doing will get the person in trouble instead of threatening them. Okay. Some communities, the rest of the directors will have me send something to that rogue president saying, I recommend you stop this because if you continue, then XYZ could occur. Now it's not protected, meaning that the association might not have the obligation to protect that director either. Okay, so you must act reasonably. Now, the good news is this fiduciary duty is judged by what I call, and it's not necessarily accurate, but it's the dumbest person in the room standard. Okay, the way that this works is as long as you could have reasonably believed that what you were doing was in the best interest of the association, you should be protected. But if you are doing something to someone else maliciously because you don't like them, and it can be proven. I mean, I have literal emails from a board member in a case I was handling that says, well, she did it to me, so I'm doing it to her. That's not a valid reason for a business decision, folks. Okay, you need to have business judgment, not emotional judgment. So you need to make your decisions on a business basis. No one board member should be making decisions for the board. Directors can't vote by proxy or secret ballot at board meetings, which we mentioned. And members of the board can use email as a means of communication, but can't vote via email. Now, that doesn't mean you can't kind of make the decision in advance and then have the full discussion during the board meeting. Some communities, and this should be used rarely, but some communities will make the decision, move forward so that they don't have to wait, since they know that every director is going to vote a certain way, and then ratify the decision at the next board meeting. That is okay. It's not preferred, but it's okay. So the next question is, what is a board meeting? Well, is it just a gathering of the board members? The answer is no. Okay, a board meeting, according to the Florida statutes, and this is 720 in particular, is when a quorum of directors gather and conduct association business. Now, that's a paraphrase. The question is, what is conducting association business? Okay, and a lot of attorneys, the opinion that I've heard from almost everyone, I don't necessarily agree with it, but that's okay. But the opinion that I've gotten is, if you are meeting with a quorum of the board and you are discussing association business, including that party that you want to throw next week for the association, that's a board meeting. And you should have provided notice. It should have been open to the members, and that's the end of it. So just be very careful that happy hour, that lunch that you're sitting down and just hanging out, once you start discussing association business, you got to shut it down, because otherwise there are some people who will find a reason to complain about anything. And this is one of the things I see people complaining about the most, is a lack of transparency, because John, Jim, and Jane sat down and had a glass of wine together. And they must have been discussing association business because they're all on the board. Well, no, they've been friends for 30 years, which is why they all agreed to get on the board together. But that doesn't matter to some people. So just be careful. Board meeting notices need to include the date, time, and location of the meeting, and there needs to be an agenda for the meeting. Every board meeting. Assessments can't be levied at a board meeting unless the notice includes a statement that assessments will be considered and the nature of the assessments. Keep in mind, for anything that is governing decisions regarding assessments or changes to the use of a parcel, which is really your rules and regulations, your amendments, that's going to be a 14-day notice. Normal board meetings, unless there's an emergency, only require 48 hours notice. Now, that notice now also needs to be posted on the association website in the notices tab that I mentioned earlier, if you need to have an association website. Any rule that's adopted needs to include a requirement that the association send electronic notices to members whose email addresses are included in the official records, in addition to posting this notice in a conspicuous location in the community, because that's generally the way that you're going to post. You're going to put your notice on the website for your meeting and your agenda all 48 hours at least in advance of the meeting. All of the documents that are going to be considered are also posted 48 hours in advance. And again, you're going to link to where the notice is located on the front page of your website anytime these meetings are coming up. Okay, we talked about this. So just like members get to speak at member meetings, the exact same rules will govern participation at board meetings. So I won't go through this in detail. Now, the only exceptions to the requirement to have an open meeting of the board are meetings between the board and the association attorney regarding proposed or pending litigation, which is attorney-client privileged, or meetings held to discuss personnel matters. Now, when I say personnel, because I've had this come up recently as well, we're not talking about the personnel of your management firm. We're talking about employees that are directly hired by the association. So if you're sitting there and complaining about your manager, or saying we think the manager's great, they deserve more money than they're being paid, those are not closed meetings. Only the board and counsel to discuss potential or ongoing litigation that's attorney-client privileged, or meetings to discuss employment matters that are employees of the association. Again, you can record. Anyone that wants to access the meeting and has a disability, this is one of the other policies that I think everyone should have, is one governing how you will deal with requests made by people or on behalf of people who have a disability and need an accommodation to have an equal use of your property. That includes the ability to physically attend a meeting at a location that's a little bit more difficult. I have had people that said, I need to attend by Zoom because I can't leave my home. Physically handicapped, can't do it. Okay, that might be an accommodation you need to provide that person. But again, if you have a policy in place that governs how you're going to deal with these things, you might not need to send every single one of them to your attorney to avoid getting in trouble under the Fair Housing Act, which we'll address later. Can't
Well,
be
Alan, to
compensated. Oh,
piggyback on that, if they're holding their meetings by Zoom or an online platform, are they required to offer a physical location as well?
generally no, unless someone asks for it. So, I mean, if you've got Zoom meetings set up in your bylaws, then you can hold it exclusively by Zoom. If you are holding it by Zoom and you don't have something directly in your bylaws stating that that's the way you're going to hold the meeting, then Heather, I think the answer actually becomes, yeah, you need to have a hybrid meeting where anyone that wants to attend in person is allowed to do so, because that's the only thing that's really allowed for in the statute. And we'll get into it in a minute, but I'll be able to skip it late once we get to it. The directors are allowed to attend any board meeting by Zoom, by phone, as long as they can be seen and heard by the rest of the members. So you could have where only the manager is in a physical room and any member that wants to attend that way is entitled to do so, but all of the directors are attending by Zoom and all of the members are attending by Zoom, but the one guy that wants to attend in person is still allowed to do that. So it really, the answer, Heather, depends what's in your bylaws. Do they allow for purely virtual or electronic meetings, or do they require, or are they silent, which would require that you have at least a hybrid option available? So good
Then,
question, and that will come in later.
lastly, so are the members required to inform the board that they're recording the meeting?
Not required. I mean, keep in mind, the members have an absolute right to record, but if you want to require at least that prior notice, you can't say, no, you're not going to record it and I won't allow it. But if you want to at least know that someone's recording, then that's something that should go into that member participation at meetings policy that I mentioned earlier. All right, so directors can't be directly compensated except for the things that are listed here. Keep in mind what we're talking about is being paid for your service on the board. You are a volunteer, unless you are not, in which case you're a developer representative, and this is your job. You probably serve on 5 or 6 or more different boards. So generally speaking, unless the governing documents allow payment, you won't be allowed to be paid for your service on the board. You can't accept kickbacks as a director, officer, or manager. A kickback is basically something that you're accepting from a vendor who is proposing to do business with the association that you're not paying for. So if a vendor offers to buy you a TV, and they say, oh, this has nothing to do with whether or not you're going to work with us. I just think it was a nice thing to do, and I think you're a nice guy, so here's a TV, have a nice day. Your answer is no thanks. And the reason is it's a third-degree felony and subject to monetary damages to accept a kickback. Now, there is an exception here. Someone can accept food to be consumed at a business meeting with a value of less than $25 per person, or services or goods received in connection with trade fairs or education programs. So when I go out with someone, I always spend a couple minutes to make it an education program, and I explain a legal topic. Not saying that's necessarily appropriate or the best way to handle it, but this way, even if someone were to challenge it, I know that this is my policy anytime that I'm at dinner with an officer, director, or a manager. Now, when I say $25 per individual, what we're saying is I can't take you to Ruth's Chris, but we can go have dinner at the Ale House. That's really what we're talking about. And trade fairs also include the condo and HOA expos. I know that Castle's got their Educate to Elevate expos throughout the state, including the one that I'll be teaching at next. Actually, it's not next week. It's this Friday. As well as the CAI and CAMU and other trade show meetings. So that's what we're talking about when we say trade fairs. Now, grounds for immediate removal, it's basically theft or embezzlement of association funds, obstruction of justice, criminal violations under the HOA Act, or voter fraud will have someone removed immediately from office if they are charged by information or indictment with those crimes. Again, what we're not saying is John says that you stole money from the association. We're saying the police have reported to a prosecutor that you stole money, and the prosecutor thinks there's enough evidence that they have charged you with a crime, and it's not just an individual, it's the actual state or the federal government charging you with the crime. The board fills that vacancy once you're off until the end of the period of the suspension or the end of the term. If the charges are dropped or there's a finding of not guilty, or without a plea of acceptance of without a acceptance of a plea of guilty or nolo contendere, director gets reinstated, period. Whether you want to reinstate them or not, whether you like them or not, they're back on. So that person that served in that interim role is now off the board, and the initial director jumps right back in. If the charge is pending, like we said earlier, they cannot be appointed or elected to any position on any association and can't have access to official records of any association except pursuant to court order. Anyone who's more than 90 days delinquent in any obligation to pay the association is treated as abandoning their seat. Now, this is a vacancy permanently. So that person is completely off the board. They cannot come back on until they bring their account or whatever they owe the association completely current. So this is a complete removal. It's not a suspension. It's you're off, period. Now, if that person happens to pay, the board could certainly reappoint them to the board, but there's no obligation to do that, even if this person pays their debt. Conflicts of interest, there's an entire class that we teach on this, so I won't get too much into detail, but just understand that there's a rebuttable presumption of a conflict of interest, meaning it becomes the director or officer's burden to prove there was no problem with what they did if they end up proposing to contract directly with the association from their own company, from their own self, or from a family member's self or company. So in other words, you need to let everyone on the board know at least 14 days before the vote if there is any kind of conflict of interest. Now, a lot of people think there's a conflict even though there is none. A lot of people think every conflict is bad. It's not. Okay? Me knowing the landscaper because he's my cousin might get me the best deal for the association because they'll do their work a lot cheaper than John down the street who's going to charge me, 2/3 more than what my cousin would charge. So it doesn't mean it's wrong if there was a conflict. It just means that there are procedures that need to be followed. Now, the procedures are here. I don't think we need to go through them in detail, but the important things to note is disclose, disclose, disclose. Be transparent about this conflict. The other thing, you need 2/3 of the other directors to vote on that item in order for it to pass, not just a majority of a quorum. The other important thing to note is that director, I mentioned there are 3 things that a director does. The last thing that they do, number 4, is they abstain from the discussion and voting on items where they have an actual conflict of interest. Now, the fact that I mentioned some people think there's a conflict, there isn't. If someone's serving on the board and the ARC, there's no conflict. Both of those entities, both of those committees, they serve the association. There's no conflict. There's no one has more interest than the other. So just because someone is serving in 2 capacities doesn't mean there's a conflict. It's when there's an actual difference of interest that director, officer, or manager has. Now, there are cancellation procedures for contracts between the association and a director, or where there was a conflict that wasn't properly disclosed and handled. If that comes up, you're going to want to run through this with your attorney. But the bottom line is, if you read through these slides, you should know exactly what to do. There are a couple different types of committees. Some are advisory, some are decision-making committees. A majority of the people on a committee that is comprised of the board need to be directors unless the committee is created by the board or otherwise authorized in the Articles of Incorporation, and the committee relates to elections, nominating, qualification or credentials of directors, because those individuals on the board can't be on a nominating committee because they're already on the board in some instances. Take a look at your documents, or more accurately, have your attorney do that. Advisory committees are basically just giving advice to the board, who then makes the final decision. They can't act, they can't exercise any authority, etc. Now, there are certain statutory committees that also exist: fining and suspension committees, architectural review, and organizing committees if you need to revitalize your covenants, which we'll get into later. They're not subject to these requirements. Okay, the same meeting requirements apply to a committee meeting if the final decision will be made regarding expenditure of association funds, or this committee has the power to approve or disapprove architectural applications. So any other committee, there is no notice requirement, there's no openness requirement. It can be completely closed off according to Florida law. Official records, frankly, as much as I would love to go through these in detail, we're on slide 51 of 200 and it's already 12 o'clock. So what I will do is basically say you need to keep all of the records pertaining to the operation of the association. And there's a whole list here, but we'll look at just this last one, the bottom bullet point here. All other written records of the association not specifically identified here, which are related to the operation of the association. Well, what the heck is not related to the operation of the association? If it has anything to do with the association, it's an official record that needs to be maintained by the association. And again, that's going to be your secretary or your manager, depending on who's responsible for your particular community. If you have a manager, you're going to read through the management contract to find that out. If not, you got a secretary who's responsible for it. Now, policy number 3 that the association now must have, effective July 1st of last year, is a policy governing records retention. How will you maintain your records? Where are they going to be kept? How will they be destroyed once these time frames expire? Now, all records need to be maintained for at least 7 years unless the governing documents say otherwise, and that's only if it's a longer period of time in the documents. Bids received by the association for work to be performed need to be kept for 1 year. Same with election-related records are kept for 1 year from the date that the election result is announced. So most things you're going to keep for 7 years, some for 1, but condo land now needs to keep certain records indefinitely, so you might want to consider that when you decide what that policy is going to state. This is another one that we prepare for community associations all the time. So how are you going to maintain your records? When and how will you get rid of them? Now, there is a list of items that are not subject to access by the members. Okay, the records that are protected by attorney-client or work product privilege are not subject to disclosure. You need to maintain that privilege. Okay, information that you get in connection with the lease, sale, or other transfer of a parcel, usually that's going to be information regarding the purchaser that has nothing to do with a member and nothing to do with the operation of the association until after that transaction occurs, at which point the board will decide, or frankly, the attorney and the manager might decide whether that record needs to be disclosed to anyone. Information can obtain in a gated community. Basically, you know, you've gotten someone's driver's license that's not a member, etc. That is not going to be disclosed to the members. Personal identifying information of the individual other than the name, lot designation, mailing address, and property address is not subject to disclosure. And the information here that's important is email addresses. If you've got email addresses that are intended only for courtesy email blasts and are not intended for official notices of the association, those email blast email addresses, just because you have them, does not make them part of the official records that you're supposed to be giving out to anyone upon request. Okay, so just understand, you don't have to give every piece of information you get just because you have it. You do need to maintain it as an official record. Personnel records of association or management employees, medical records of owners or residents. Usually you'll get that in connection with a disability related request or a personal injury lawsuit or something of that nature. And anything that allows the manipulation of data or passwords or things like that. And then the affirmative acknowledgments regarding people agreeing to a different method of being invoiced for assessments that come due. All those things are not accessible to members. Now, we talked about attorney-client privilege. Basically, this is any time that you are discussing strategy with your attorney regarding potential or ongoing litigation, and any of the other things that are described in this first bullet point here, those are not subject to disclosure to the members. Only the board, the manager, and the law firms that are working with the association are entitled to that information. It is not any individual director's prerogative to decide to disclose that information. It is the board's prerogative to decide. Even if I'm your attorney, I don't get to decide whether to give that information up. The Florida bar rules say I can't give it up. I'm legally prohibited from giving it up unless the board authorizes me to do so or a court directs it. And even then, I might say, I'm sorry, I'm constrained by attorney-client privilege and get myself in trouble to protect a client. Because that's also part of the fiduciary duty that everyone owes, including attorneys owe that fiduciary duty to the association as a whole. Correspondence from the lawyer remains privileged unless the board votes to waive that privilege. And again, only the board gets to vote to waive the attorney-client privilege. Membership directories, you can have, a member can exclude their phone number by requesting that that phone number be excluded. They can also consent to disclosure of other information that they could otherwise say, I don't want it in there. Rules and covenants. So this was effective July 1st of 2024 and required by October 1st. So hopefully everyone that's here has already done it, but you need to provide a physical or digital copy of the rules and covenants to every member. The way that a lot of communities do this that I work with personally is the first thing I do, as I mentioned, when I bring on a new client, is compile all of the governing documents, including the rules and the covenants and the bylaws, the articles, the plats, and all of that into one PDF. And then I send a copy of that PDF on to the manager or the board as appropriate. So some communities are just sharing that document, and that takes care of this requirement. If you haven't already done it, that might be a quick and easy way to put this together for your community. The association must provide a physical or digital copy to every new member. So anytime you have someone buy into your community, these must be provided as well. That's a good reason to keep it digitally because you'll save a lot of money, and especially putting it directly on your website, you'll save a lot of money by not having to print this out every time you've got a new member, which could cost hundreds of dollars. I mean, I have a community that we recently started working with. Their governing document book is 1,500 pages. And maybe we wouldn't need to give all of that to new members, but we need to give most of it to them. So just keep in mind, you're going to want to make this available. Hopefully, again, everyone's already complied with this, so I won't go into too much detail. So moving on, access to official records. So we mentioned what the official records are, what you can and can't get access to. Now, what happens when someone makes a request? This is policy number 4. Records inspections. Before we talked about records retention, this is a separate policy regarding inspection of the records. So anyone that sends something to the association requesting to view the records and inspect them and copy them is allowed to do that as long as they're a member of the community. Now, the inspection needs to occur within 45 miles of the community or within the same county within 10 business days after receipt of the written request. The association can have a copy available, make them available electronically by internet, or allow them to be viewed in electronic format on a screen and printed upon request, for example, in your office or the management office. If the request is submitted by certified mail, return receipt requested, and you don't provide the access within 10 business days, there is a rebuttable presumption that the association intentionally failed to comply with its obligation to produce the records. Now, that rebuttable presumption means that it's no longer the burden is on the owner, or I'm sorry, on the association to prove that you did what you could. Now it's on the association to prove that, well, there's no way we could have complied. It wasn't intentional. So leave that burden on the owners, comply within the 10 business days, make it easy on everyone, and you won't have any problems, at least not in this regard. Anyone who's denied access to these records is entitled to $50 per day starting on business day 11 up to $500 total, plus their attorney's fees and costs, plus any actual damages incurred. So bottom line, make your records accessible. If you can put them on your website and not have to worry about most of this, please do that. Make it easier for you, make it easier for the members, etc. Now, this is a new law that basically if you get a subpoena from law enforcement, you've got 5 business days to produce whatever those records for the law enforcement agency's inspection and copying unless the subpoena says that you have more time. The association must assist law enforcement in its investigation to the extent permissible by law. I'm guessing that someone decided they weren't going to give up official records in connection with a criminal investigation into the directors, and this is why this came about this year. I have never seen this situation come up, but you never know what the legislature is going to do next. My favorite law professor's line, his famous line was that you're never safe and nothing is safe when the legislature is in session, and that is found to be accurate over the last 2-3 years. So the new laws, again, that came into effect, if you knowingly, willfully, and repeatedly, meaning 2 or more violations in a 12-month period, failed to provide access to official records, that is now actually a second-degree misdemeanor. If you intentionally deface or destroy accounting records while they're supposed to be maintained, or fail to create those records with the intent of causing harm to the association or a member, that's a first-degree misdemeanor. And anyone who willfully or knowingly refuses to release or otherwise produce records in trying to get away with a crime commits a separate third-degree felony. So bottom line, produce these records when they're requested, please. If you're not sure whether you should be producing them, run that by your attorney and make sure that you're doing it right, because you don't want to give away that $500 gift plus attorney's fees. You can adopt reasonable rules. We talked about that. What you can't do in connection with a records inspection request is require an owner to show a proper purpose for the inspection. The fact that they're a member means they have the right to do it, period. Require them to state a reason for the inspection, or limit the right to inspect the records to less than 1 8-hour business day per month. So what we're saying is adopt those restrictions so that you don't have someone like some of the people I've dealt with who are sending a new request once a week and requesting the same records over and over, or requesting different records once a week, rather than I'd like to inspect the records for 8 hours. Okay. Now, keep in mind, they also don't need to cherry pick what they want to see. They can say, I want to inspect the records and copy. That's good enough. Copies are free up to the first 24 pages. If it's more than that, you can charge up to 25 cents a page. Now, you have to have a written resolution that says you will charge that. That could be part of your records inspection policy. If they are scanning it to a portable device or an actual scanner, that's free of charge. So you can't charge people for copies that they scan or for digital copies unless you're actually being asked to print it or produce your own thumb drive for them. Personnel costs. If the records need to be pulled from some kind of storage facility and the time to copy or retrieve exceeds a half hour, the personnel costs can be charged, but only $20 per hour. And I don't know many management firms where that is the actual charge. Usually it's closer to $50 to $150 per hour for any manager that's doing this excess work, so to speak. Can't charge for 25 or fewer pages. Okay, the website. Again, 100 parcels or more, you need to have a website or a downloadable mobile app. I do know some, I think Everbee is one of the communities locally here that has its own app instead of a website or in conjunction with a website. A lot of web developers will actually set up an app that's literally just a copy of the website that makes it easier to click through and is very accessible. That might be something to consider. Now that we're a little bit more techie in the last few years, you do need a username and password so that you're protecting the association information from people who don't have an entitlement to see it. So a lot of this documentation should be behind login credentials, so to speak, other than maybe your governing documents and other things that are already recorded in the county records. Now, documents we mentioned, a lot of these are the same records that need to be posted or that need to be kept as official records. There are very few distinctions, so I'm not going to go through them in detail. If you're not sure of what you need to maintain, I just did a webinar, literally, was it last week, with my partner, Jeff Rembaum, which should be up on our website shortly if it's not already, with Castle Group, that you might want to check out so that we can skip through some of this detail regarding official records, but we've covered what you need to cover so that you can get your credit. So we're going to move on since we're still at slide 71. Okay. Amending the governing documents. What this means is you're making changes to the way your community operates. Now, I have a list of about 20. We do have a class that we offer that teaches about amending the governing documents. We probably have a recorded version online, but I don't think we've done it since I started doing it, where I'm just naming 20 or 30 things that I think everyone should be considering if these provisions aren't in their documents already. So feel free to reach out if you're considering working with us on a review of your governing documents and whether or not that these amendments might be something for your community to consider. But moving on, the percentage that's required, unless your governing documents have a lower percentage, 2/3 of the voting interest of the association would need to vote in order to adopt amendments to your governing documents. That's your articles, bylaws, and declaration. The format is specific. If you are preparing these amendments yourselves, you're doing it wrong. I can almost promise you're doing it wrong because you're not going to write it in a legal format, and you're probably missing points that you need to make. A lot of people ask, well, is it better if we write these down and then send them to you to review, or if you draft them? 99% of the time, I think it's better for the association, the board, to give bullet points to council of what the changes are that they want to make and let council draft it rather than try to clean up what the board attempted to do. That's actually going to cost less as a standard practice than trying to clean up what the board did. A lot of declarations say that the lender needs to consent to all amendments. The statutes were changed over a decade ago to basically allow for negative notice to those lenders when you're doing an amendment. You don't need to send it at all unless you are doing something that impacts the lender's rights. And if you are doing something that does impact the lender's rights, for example, you're taking away safe harbor language in your declaration or taking away the subordination clause in your declaration, that would be something that would be impacted separately by the time that you're recording it, etc. So don't presume that that's going to work. Run that by your attorney as to whether it'll affect existing mortgages. But if you make that change, you give 60 days notice to all lenders in the community that, hey, we're making a change to the provisions that impact you as a lender who has a recorded mortgage against the lot in our community, and you have 60 days to respond objecting to the changes, or we are allowed to legally presume that you have no objection and you've waived that right to object. If that 60 days passes and your members vote in favor of the amendment, you can record it and it'll be effective. It just might not be effective as to that individual lender, depending on certain factors that I think would be a waste of time to discuss today, but we can discuss separately if you want to give me a call or shoot me an email. Developers can't exercise unilateral power of amendment, which most developers put into the declaration until that turnover of control of the community occurs. If that amendment would alter the general plan of development, basically you can't sell a bunch of lots that people bought thinking the community was going to look like X and make the community 3. Okay, it's got to look like it was supposed to look like, because people are relying on what's in the governing documents, even if they haven't read any of the governing documents before purchasing their lots when they bought in. The effective date is the date of recording the amendment, so it's not effective until it's recorded is really what we mean there. I have plenty of communities that think they have amendments to their bylaws or their declaration, and when I say, well, I didn't locate that in the county records, and their response is, but we thought it was effective and we've been using it for 10 years. My response is you should probably get that recorded now. Within 30 days after recording the amendment, the association must provide copies to the members. If a copy of the proposed amendment is instead provided to the members before the vote to approve the amendment, you just send a notice saying, here's the recording information for the amendment, instead of sending an actual copy. Amending leasing restrictions, we have an entire class on guest restrictions. I would suggest you check that out. All of these classes that I mentioned, by the way, are at our website at kbrlegal.com under the resources tab. You'll just look at the videos that are up and scroll through to find the class you're looking for. Those are all free. They're on YouTube. You won't be able to get credit for taking the class, but you will be able to get the information, which hopefully is the more important part. Any governing document that is enacted after July 1st, 2021 that prohibits or regulates rentals only applies to people who bought in after the amendment was put in place and recorded, or who actually voted in favor of it. But we've now got a statute that came in, I think it was 2021 or 22, that says you can limit short-term rentals, and that will apply across the board. So if your term is that you can't rent for less than 6 months, or more than 3 times in a year, that will apply across the board, even if people voted against it. Now, you have to get the proper vote for it to pass in the first place, but it will apply even to those people who voted against it. These rental amendment restrictions don't apply to associations with 15 or less owners. Keep that in mind. Now, we're not going to go through this, but you should read through it if you're considering leasing restrictions being adopted. No discriminatory restrictions. We talked about that. Board only vote if you have a discriminatory clause in your documents. We don't have time to go through all of these, but they are important things to know. The Marketable Record Title Act is something that I wish we had a class on because it's very important. But the bottom line is make sure you're working with an attorney who cares enough to track when your covenants will expire so that they don't. Governmental filings, just keep in mind every year, you do have to file an annual report with the Division of Corporations of the state of Florida between January 1st and May 16 and pay a filing fee. Make sure to get that done on time because it goes from like $100 to $500 overnight if you don't get it done in time. And then annual income taxes also need to be filed. The fact that you're a not-for-profit corporation doesn't mean you don't need a tax return. It just means you might not pay taxes. So make sure to do that. Meeting minutes are the next thing that we want to talk about. All meetings must have minutes taken. They don't need, pardon me, they don't need to be verbatim records of every word that was said during the meeting. They just need to be something that says, here's what the vote was. So your meeting minutes can be as short as, and frankly should be as short as, here was the motion that was made, here's who made it, here's who seconded it, here's how each director voted or abstained. That's it. And by the way, I mentioned you can abstain from voting. That is not because you don't like the options. That is because you have an actual conflict and you are not allowed to vote. If you don't vote and you abstain just because you don't like the available options, that means to me that you're in derogation of your duty and or dereliction of duty, sorry, as a director, and you're not doing what you were not hired, but you were brought on to the board to do. Minutes need to be maintained in written form or in another form that can be converted into written form in a reasonable time. And those should be in your official records. As soon as those minutes are created and adopted and approved, they go into the official records. Now, people ask, well, video of records that were held via Zoom, I'm sorry, meetings that were held via Zoom, is that an official record? The answer is yes, until you have meeting minutes of that meeting. So you don't have to videotape every meeting. But if you choose to do that, you can delete that recording, and it is not something that you have to comply with your records retention policy as soon as those minutes are adopted from the meeting. Okay, moving forward, material alterations is mentioned earlier on in that here's a bunch of things about HOA's slide. A material alteration is when you're changing a physical, visible aspect of your community. Generally, you don't need to get member approval before you do this when you're talking about changes to common areas. What you need to look out for, though, is does this change impact the dollar figure cap that we're allowed to spend without getting a member vote? Some of these are as low as $5,000 in some community associations. Now, then you can talk to your attorney, but there is case law that says, well, you know, even if there's a material alteration required vote, if you had to do it or if it's more protective, you don't need to get a member vote. There's a lot that goes into this, and you'll want to discuss this with counsel before you decide whether to do this type of change without a member vote. Just talk to your attorney, get a written opinion, and then the association, or at least the board, is protected in deciding not to get that member vote. Rules and regulations we talked about, you need to make sure that they are not in conflict with, and they are in some part supported by your governing documents, your declaration articles and bylaws. If not, they might not be enforceable. So keep in mind some governing documents, which I think should be amended away to the extent possible, will say that the members get to decide on board-made rules. I think that's a bad idea. The whole purpose of this is to make sure that the board has the ability to meet the needs of the community. If you have to get a member vote and you're not able to do that, so you can't change the rules, that creates problems. So we talked about the 14-day notice before you're changing parcel rules. If you are changing rules governing, let's say, how to use the clubhouse, how to use the tennis courts, whatever you've got, amenities and things like that. That's not parcel use. So understand, I said 14 days for parcel use. That's not parcel use. It requires only a normal board meeting notice to change those rules. So I mentioned the Marketable Record Title Act. This means that after the initial recording of the declaration, and this is a vast oversimplification, but 30 years after your declaration is recorded, you need to make sure that you have something that specifies that you are preserving all of the covenants of the association. Otherwise, they expire and they need to be revitalized. Now, as of now, that expiration can be avoided by having a 1 to 2 page document that outlines that you want to preserve these rights, that basically identifies the recording information for each covenant that you want to salvage. And that's usually fairly low cost. The alternative is a preservation or revitalization, which is basically bringing your covenants back into effect, which costs a lot more and requires a majority of the members to vote in favor of revitalization. Keep in mind, when your covenants expire, I have a lot of people saying, well, why don't we just let it expire so we don't need to deal with this? The corporation still exists when that happens and still has the same obligations. You still have your drainage areas that need to be maintained and insured. You still have all the same responsibilities as an association. What you don't have is the ability to charge people assessments or force them not to paint their house pink with purple polka dots anymore. So you want to make sure those covenants are preserved. Now, when we do an amendment to a declaration, usually we're including language in that amendment to preserve those covenants as well. So that might be another way to extend this out a little longer. You need to let process servers into your community if they are serving documents related to a lawsuit. There are a lot of new restrictions regarding community association managers this year. One relates to conflicts. One relates to getting alternative bids. But frankly, we're at 12:30 and not halfway through the slides, so I'm going to move on. There are a bunch of emergency powers. Now, I know that a state of emergency has been declared in the state of Florida as of this recording because it's damn cold, and we don't know how to deal with that in Florida. Jeff, I'm sorry, you're in Alabama. It's even colder. I know you like that weather, but I stayed in Florida when I moved out of South Florida for a reason. I don't even want this 50-degree weather. Yeah, exactly. But the bottom line is when a state of emergency is declared, which has a risk of damaging or injuring people or damaging property in your community, you have a state of emergency that will allow you to use these emergency powers. So this is the time to consider if you want to pass that special assessment without a member vote, things of that nature. I'm not suggesting that you do it across the board. What I am suggesting is that you take a look at this with your attorney and make a decision as to whether or not these emergency powers that have kicked in as of this recording are going to help with some of the things that you need to accomplish. The purpose of these powers is to protect when there's a hurricane, when there was a pandemic throughout the country, but it's not limited to a state of emergency declared in the nation. It can be nationwide, statewide, countywide, municipal-wide, or just something that is in your city alone. As long as there is a declared state of emergency by the government, you will be able to use these powers. I won't go through what they are in detail because frankly, I get asked about them maybe once or twice every 2 to 3 years. But the bottom line is you should be aware that these things will kick in when there is a state of emergency, and consult with your attorney who hopefully will be available to you during that state of emergency. And if they're not, feel free to email or call me. That person should be guiding you through what you can and can't do during that potentially catastrophic event. Driver's licenses. You do not swipe driver's licenses unless the person consents. You take a picture of the driver's license, that's fine. You take the driver's license and write down the information, that's fine. You take the driver's license and just look at it, that's fine. What's not okay is having your guard gate swipe people's licenses that haven't consented to it. Okay, you can get the information that's on that card in other ways. This is Florida law. It is unlawful. Whether there's any criminal penalties, I don't believe so, but bottom line, why violate the law? Another one, debit cards. I have a lot of communities that their board says, well, it's in the association name and We just want to keep using it because it's hard to give our personal information to get a credit card, or it might impact our credit because they won't give a credit card in the name of the association. I know of banks that are giving credit cards without personal information because they're basing it on the funds available to the association. So it is a crime in Florida to use a debit card as a director for an association expense, even if it's a proper expense, if it hasn't been approved in advance in adopted meeting minutes or a written resolution that's been signed by the directors. So bottom line, figure out a way to get that credit card. Reach out to me if you need to be put in touch with the banks that are issuing credit cards to associations, or use your own debit card, which is also fine, and get reimbursed after that approval is given by the board, so that you don't run afoul of this criminal statute, which is part of 720, but does make it a crime to use a debit card. It's considered theft in the amount of whatever you purchased, even though it was an item that was purchased specifically for the association for its use and was given to the association for its use. Bottom line, don't mess with debit cards. Deposits that are taken as either a rent deposit or a deposit related to a construction job can't be commingled with other association funds. Now, once the project is done or the tenant moves out or whatever the case may be, the deposit needs to be returned to the member within 30 days after receiving notice that the project is done. I say the member. What I would suggest is when this deposit is being made, have something that each person signs that says who's going to get that money back at the end of the day. Because I have had situations where the parties were fighting over who's entitled to that money. The association gets brought into it because you give it to one party or the other, and then the association gets sued because, well, you gave it to the wrong guy. Okay, well, how was I supposed to know who the right guy was? But you would know if you got the document signed that I'm suggesting. If a member makes a request for an accounting from the association for the funds that were deposited, you must provide that accounting within 7 days after receiving the request. Keep in mind, this is 7 calendar days, not business days. Litigation authority. If you're going to file a lawsuit and the damages, the amount in controversy, is more than $100,000, you need a member vote of a majority of the members. Where I see this being improperly used is where the attorney's fees are going to exceed $100,000, which is not what the statute says. I also see it being used by contractors. For example, the association sues the contractor that put on a new roof, and the contractor says, well, they didn't get the member vote. Who cares? You're not a member of the association. This is to protect the members. This is intended as a shield, not a sword. Meaning it's intended to protect the members, not serve as a defense to a lawsuit by some outside third party that the association contracted with. So usually what's going to happen if you didn't get this vote in advance of filing that lawsuit, which your attorney should be telling you need to get, by the way, if that lawsuit in excess of $100,000 is going to be filed. But if you didn't do it because your attorney doesn't know community association law, they really practice real estate, and they're saying, well, yeah, I can represent your association. Sure, I know real estate law. They don't know community association law. They're not going to do this right. But if they do it wrong, the good news is you basically just go back to the members, put the case on hold, get the member vote, and come back to court once you've got the required vote. Architectural control. Okay, so you need to have written criteria if you want to enforce any criteria. It needs to be specifically stated or reasonably inferred in the declaration or established architectural standards as to the location, type, size, or appearance of anything that you want to be able to govern from an architectural standpoint. When we say architectural, I don't mean just building, construction of buildings. What we really mean here is you are putting anything on a lot that is visible. If the guidelines provide for the use of materials, the size of the improvement, the design, or the location, the association can't restrict the right of an owner to select from those options. In other words, you can't say it's okay and then say it's not okay. If you want to be able to say it's not okay, you need to amend those specifications. Now, this is something that, in my opinion, every community association that has the right to do an architectural control review should have established written standards. Now, an association must reasonably and equitably apply and enforce all of these standards. And if you deny a request effective July 1st of 2024, you need to specify what provision of the governing documents you're relying on to say no. Okay, and the specific aspect of the improvement that doesn't meet the rule. So you need to be really specific now when you're denying these requests. Why are you saying no? What part of the project is not acceptable, and why is it not acceptable according to those written guidelines or according to the declaration? So if all you've got right now is, well, the association has the ability to decide what's reasonable and what's not on aesthetic grounds, and there's no standards established, nothing in the declaration specifying what materials should be used, what colors are allowed. I hate to tell you, but you don't have an enforceable architectural provision for the most part. You can make the argument, you can adopt a single rule that says that the current status of everything in the community is going to be the standard that we meet, but then you're going to have to go drive around the community every time you want to review an architectural application to make sure that there's no one else that already has the thing that this person is asking to have. So just keep in mind, you need to be fairly reasonable. The owner can actually recover damages if you said no, including fees and costs. And I have seen some owners that are irate enough after being denied this request to go ahead and file a lawsuit. The association cannot enforce or adopt a covenant rule or guideline that limits or places requirements on the interior of a structure that's not visible from the frontage or an adjacent parcel, an adjacent common area, or a community golf course, or requires the review and approval of plans and specs for a central AC, refrigeration, heating, or ventilation system if that system isn't visible from those locations. Now, keep in mind, this is one of those things that while it might seem reasonable, it is an impediment on the existing rights of the association. So you're going to want to run it by your attorney, whether this statute actually applies to your community or whether it's something that you're allowed to fight. That doesn't mean you're required to fight it just because you have the ability to do so, because in order to succeed on a challenge to the constitutional aspect of these new statutes, we talked about that Kaufman language earlier, as amended from time to time. If you don't have that language, this is a substantive change to the way that you're supposed to be operating. The association's rights include enforcing its criteria and its established guidelines. If you have those guidelines and the statute says you can't have them, then that would be technically unconstitutional for your community. Whether you want to fight that depends whether you want to spend possibly hundreds of thousands of dollars so that you are able to enforce this going forward. Now, I would not rely on whether or not it's worth it for your particular community to do that, because there might be a group that's interested in funding that litigation so that many communities in Florida get case law in their favor that says that these statutes are unconstitutional if you've got these provisions that are not in the governing documents. You don't have Kaufman language. But whether you want to take the risk that you have to spend that money or you want to go to only a certain point and then stand down is a decision that each board needs to make. But the first thing you need to do is get with your attorney and find out whether you even have a reasonable basis to make that argument, because you've got or don't have Kaufman language in your declaration. Now, in addition to these specific internal things that aren't visible, any covenant that says you can't do something on a lot that is stored, displayed, or installed on a lot that's not visible from the frontage or an adjacent parcel or an adjacent common area or community golf course is not enforceable. Again, constitutional argument up to the board, but this is what the statute says. So you're going to see people that are raising the statute as a basis for a challenge to enforcement efforts. Whether or not you want to allow that to slide, or if you want to continue fighting it, because as to your community, the statute's unconstitutional, is a board decision that should be made with information received from your attorney as to whether you have the right to fight this. If your attorney just says this is what the statute says, that's not someone who's aggressive enough for your community. It's someone who should be giving you guidance. That's what a counselor and attorney actually is supposed to be doing, not just stating what's in the statutes. So moving along. Flags. There are certain flags and flag poles that are allowed in the community, regardless of what your governing documents say. This is one that I would not fight because it's mostly military, POW, MIA, and first responder flags. But up to the board, I will not be the attorney that fights this one if it is a US flag and you're telling someone they can't fly it. Now, if it is in excess of what's allowed under the statute, yeah, okay, I'll fight that battle for you. So make sure to take a quick look at this before you tell someone they can't have certain flags on their property. Hurricane protection. This is another, I think it's item 5 that the policies that you must have now. This is number 2 of the must-haves effective July 1st of last year is hurricane specifications. What are you going to allow? What are you not going to allow? What needs to be on a lot, etc. And you can't deny an application for installation of something that conforms to these specs. So if you want to say you can't have plywood and nothing else on your property, that's something that you need this policy to have. Now, the bottom line is you are legally obligated to have this policy already in place. So if you don't have this, if you don't have the records retention policy, you need to get with your attorney right away. Start by asking them why they didn't tell you you have to have this, and proceed by asking them to draft it for you. Vehicle restrictions, again, same thing, constitutional issue, but the statute effective July 1st of last year says you can't stop someone from parking a personal vehicle, including a pickup truck or a work vehicle, regardless of commercial markings in their driveway. Now, operating a vehicle that's not a commercial motor vehicle as defined in the commercial motor vehicle statute is something you also can't restrict. A commercial motor vehicle, I think, is 26,000 pounds and at least 3 axles. So if that's not what we're talking about, which is basically a semi, it's not going to qualify as something that you can restrict despite this statute. Again, constitutional issue, run this by your attorney. Contractor restrictions, same deal, constitutional issue. Effective July 1st, you can see the legislature loves HOAs and condos, giving the things that you suddenly can't restrict in an HOA as of July 1st of last year. You can't restrict an owner from having a contractor on the property just because they're not on a preferred vendor list. I'm okay with that. But here's the one I have a problem with. You can't prevent them from using a contractor that's not licensed. What? That's what the legislature thinks is okay. The fact that someone is not licensed does not mean that the association can tell them they can't do work in the community. I think this is a huge risk. I think that having unlicensed work done in the community creates the risk that there are bad liens against property in your community. But there's really nothing that we can do to control this one unless someone wants to fight it. And I don't know whether this would be considered procedural or substantive. I think it would probably be another substantive issue that you could challenge if you don't have Kaufman language, but up to the individual boards as to whether or not this is something you want to get into. Budgets and reserves. The most important thing I can say about your budget is it is not something that needs to be followed line by line all year long. You do not want to back into your budget. You do not want to underfund your budget. Your members have the right to know what it's actually going to cost to properly maintain and operate your community throughout the course of the year. So if you water down the budget, what you're doing is guaranteeing you don't have the money to do things that you're legally obligated to do because you wanted to look good first. You don't care what happens throughout the rest of the year when you don't have the money to do these 5 projects. When you know your amendments need to be done, you need to update your governing documents. When you know that there's collection work that needs to be done, which, by the way, is yet another policy I think every community association should have, is how you're going to collect and when you're going to collect and what you're going to do, how to automate that process so the board doesn't need to vote every time someone's delinquent. Same thing with, are you going to perform covenant enforcement, or are you going to say, no, we don't have the money to go after those people. We're just going to let this person violate the covenants indefinitely. Not a great call. Okay. So the bottom line is you want to have all these policies and procedures in place, and you want to make sure that you're doing everything appropriately according to the governing documents. It's up to the members to say, we don't want to pay that. Here's an alternative budget. But you need to comply with your fiduciary duty as a director and officer to say, here's what we really need. If your budget needs to be increased $1 million this year, You need to increase your budget $1 million this year. And if you come to the members and say, we think you should propose an alternative budget, but we are legally constrained to do what we think it will actually take to properly maintain and operate this year, that's what we're going to do. Fine with me. So bottom line, don't back into the budget and not spend money just because it wasn't in the budget. Don't underfund the budget so that you look good to the members. Put in the budget what really needs to be in there and explain why it was necessary. Be transparent. And honestly, a lot of the time, that's all that needs to be done. Okay, the annual budget needs to reflect the estimated revenues and expenses for the upcoming fiscal year and whatever surplus or deficit you expect at the end of the current fiscal year. So are you going to be left over with another 50 grand in the coffers that's in operating funds that you can use for next year so you can budget a little bit less? Or are you going to be underfunded so you need to budget more next year? The budget needs to separate the charges paid for recreational amenities, whether it's owned by the association, the developer, or somebody else. Budget needs to include operating expenses and reserves if you have any. Now, if you don't have reserves, you don't need to include those in the budget. In a condo, there are statutory reserves. There are none in an HOA. In an HOA, there's only 3 ways to create a reserve. One is in the governing documents themselves. Okay, if your governing documents don't say you need to create a reserve and maintain it for X assets. And a reserve is just money put away where when the roof fails, we have the money to fix it. That's all a reserve is. It's here's an asset. We want to make sure we have the money to fix it when it goes bad, when it's expected to fail. Number 2, reserves can be created by the developer. Okay, that needs to be somewhere in writing. We're creating this reserve. Here's a resolution or something of that nature. Same thing, it can be created by a majority vote of the members. If it's not created in one of those 3 ways, you don't have a reserve. You have a category of your operating budget. So keep in mind, that's something that you might want to have your attorney take a look at. In the last year, I've had 5 clients who thought they had reserves in an HOA and found out, nope, we've got no documentation as to how or why this was created. So we've just got another line item in our budget for money that's being put away that we can really use however we want. Now, you might want to consider using last year's actual expenses plus inflation to start planning for next year's budget. That doesn't mean that last year's budget plus inflation should be all that you look at. If you've got contracts that are going to increase, you're going to want to increase your budget by those amounts. So, for example, your landscape budget goes up 3% a year according to your contract. Well, you should be budgeting for that 3% increase, not budgeting for the amount that was due last year. And then monies in the operating section of the budget are not limited. So if you have a lawsuit that you need to handle and you have $8 million in landscaping, but only $10,000 for your entire legal budget for the year, you can use some of that landscaping money as long as it's not in a reserve for some reason for the legal expenses. Operating expenses portion of the budget basically is here's what we expect to have to spend. They must be listed by account and classification and should project the total proposed annual expenditure, meaning what are we going to spend for this item? Here's some line items. We won't go through them in detail to save some time. We talked about reserves. There are a couple different definitions here, but most HOAs, frankly, don't have reserves. So we're not going to go through them in detail. I already outlined what these might be. Now, how do developer reserves get funded after turnover is the question asked at the bottom here. They get funded by the members. Now, the developer might have an obligation to pay into that reserve because they haven't been funding it all along. That's something when you get turnover, you're going to want to take a look at everything involved in what the developer did. You should be getting an audit, whether you trust that audit that's probably from someone who's done over 100 audits for that particular developer, kind of up to you. My suggestion is get your own engineers out to your property and take a look. Make sure that there's no problems that need to be addressed as soon as possible by that developer now that they're out of the control phase. Member created reserves we talked about. Now keep in mind that calculating reserves is basically taking the estimated useful life of that asset and dividing it into what it's going to cost to repair or replace that asset when it's expected to fail. Pretty simple. There are 2 different types of reserves. One is, and these are accounting methods more than types of reserves. One is straight line. Okay. I need a line item for my landscaping. I need a line item for my roof. The other is a pooled method. I have a pool of 5 different reserve assets The next one that's expected to fail is all I'm required to reserve the funds for. In a line item reserve, you're putting away money for everything unless you've already got what it's going to take to fix that item every single year. So pooled reserves tend to be less dollars, and it's really up to the board which one you want to use. I don't really have a preference. Frankly, the one with the least cost might be best. And if you want to use that money that's in the reserve for literally any other purpose, or not put the money away that particular fiscal year, or, reduce the amount that you're putting away that fiscal year, you do need a majority vote of the members. So here's what we have right here. I guess I mentioned it a little earlier, a little early. We talked about this. Let's see. Oh, the board gets to decide whether to submit that to a member vote. It's not just the members ask for it. So whether or not you want to put away that money that year, you want to waive or partially fund, or you want to use the money for another purpose, that's going to be a board decision whether to have the members vote on it. But keep in mind, you can't do it unless the members vote on it. You can also terminate a reserve, which is a majority of the total voting interest of the association needs to vote in favor of terminating. And then depending on whether it is in the declaration or not, that might be enough. If it's in the declaration, you probably need to amend it out altogether, not just have that majority vote. Adoption of the budget. Again, this is a board meeting. It's not a member meeting to adopt the budget. So the board is the one that's going to send out the budget and say, here's what we think it's going to take. You technically only need 48 hours notice of the meeting, but the problem is you're adopting assessments, because that's what your budget is. Your budget divided by the number of members paying is the assessment for each member for the year. You can divide that up into 12 months, 4 quarters, semi-annual or annual, but that's where the assessment amounts come from, is your budget. So technically you're adopting assessments. My opinion is you need a 14-day notice, not just 48 hours. You'll also need to provide a copy of the budget in advance, or a notice that the budget is available to inspect and review. And by January 1st, if you have to have a website, you will also need to post the proposed annual budget on the website if it's to be considered at the annual meeting or in conjunction with the annual meeting. Because again, this is a board vote. Unless the governing documents require the board to provide a copy, you can do so, but you're not required to. I'd consider sending it to all the members anyway, just to be safe. After the budget is adopted, you need to provide everyone with a copy or written notice that a copy is available at no charge to the member. Just put it on your website and you're done, is my opinion. And if requested, a copy must be provided within the time frame set forth in the records inspection statute. So that's 10 business days after you receive the written request. Again, put it on your website once it's adopted, so you have your proposed and adopted budgets on your website. Assessments and foreclosures is another thing we have an entire class on, so I'm not going to go through the entire procedure. But again, this is one of the policies that I mentioned I think every community should have to automate the process. Because if you're holding this up, keep in mind, I mentioned the assessments is how you fund your association. It's how you get the assessments. You take them from the budget. So if you're not getting paid and you are allowing people to continue not paying, what you're doing is putting the burden of running the community on the few people who are choosing to pay. Also, if you don't go after the people that are not paying, more people start not paying because they see that you're not taking this seriously. So I recommend having an assessment collection policy. We also have a special program for collection of assessments that some firms have. I think ours is a pretty good one. It essentially will allow the association to pay a little bit of money up front for the year in exchange for us taking on all of the fees and costs for all new files, whether that's 1 or 150,000 files for your community. We won't bill you for that work until the file is closed. If the owner pays before we have to send that bill, you'll never see a bill for that file. So if you'd like to discuss that, feel free to get in touch. I won't go into too much detail because frankly, this is about the class and not about a pitch. Special assessments. I mentioned you need a 14-day notice. That notice needs to specify the purpose of the assessment. What are we actually trying to put money aside for and get money for that wasn't included in the budget? Or it could be underfunding the budget that caused the need for the special assessment. It also needs to state the proposed amount of the assessment and the date when it might be due. It needs to be sent in the manner that all meeting notices get sent for the member meetings, even though this is generally decided by the board. You're going to want to look at your governing documents to see whether the board gets to decide or the members get to decide. Now, in certain instances, even if your governing documents say that the members decide, the board might have a legal obligation to go ahead and do this. And there is Florida case law that says if the funds are needed to deal with certain types of issues, it's going to be something that the board gets to vote on anyway. So that's one where don't just presume that because your governing documents say you need a member vote, that that's what's required. If you don't agree with your attorney as to whether a member vote is required, you're always welcome to consult with a secondary attorney. Special assessment that's not been paid by an owner is collected the same way as regular assessments. So that's lien foreclosure. If membership approval is required but can't be obtained, what does the board do? Well, you can get a loan, or you can try and find some other funding mechanism. You could potentially amend the budget to include these funds. The problem is usually when you're levying a special assessment, it's because you need the funds quickly. And so, the loan is usually going to be the better option there, but that might also require member approval, so be careful. Let's see, providing an accounting. So if someone requests an accounting because they are told they owe some money, effective July 1st of 2024, the association must provide that accounting within 15 business days after receiving the written request. After someone makes that request, they can't make another one for 90 calendar days. Now, I've seen this misinterpreted, so look at this third bullet point in detail. If you don't respond within 15 days to a written request for a detailed accounting, it is a complete waiver. Great. Not the assessments, though. Complete waiver of any outstanding fines. So if you wasted your time levying fines, which I won't get into today because we just don't have the time, but if you wasted your time levying fines against an owner and they requested this thing and you didn't give it to them, you didn't give them the accounting, those fines are deemed waived. You can't collect them anymore. Okay. If you didn't give the proper notice, the fines are waived. The assessments are not waived. If you charge them for new keys, that charge is not waived. The only thing that's waived if you don't comply with this timeline is fines. Bottom line, though, complying with a 15 business day timeline. If you can't give an accounting within 15 business days, chances are you screwed up by charging this thing in the first place. If you want to change the way that you're delivering the invoices for people to pay their assessments, you need to have them actually opt in, and you need to send the notice at least 30 days before you're going to send the new method of delivering the invoices. This is for your assessments and all the related charges. So just be careful with doing it that way. That affirmative acknowledgement needs to be maintained with the official records. Like I mentioned earlier, it's not subject to inspection and copying. So keep in mind, you might have to send your invoices for unpaid assessments or for the assessments that are levied as part of the budget in multiple different ways to different owners who have or have not opted in to that new method. This is really when you're sending your coupon book instead of sending an email to the members who have opted in to email notices, or you've sent a letter saying, here's a list of the assessments and when they're due. If you're going to change from one to the other method of delivering this notice, the members get the opportunity to opt in. If they don't opt in, you need to use the old method until they opt into a different method. This is obnoxious and ridiculous in my opinion, but it's what the statute says. Now, you have an automatic right to collect interest on unpaid assessments. That's 18% per year if nothing is stated in the governing documents. You do not have an automatic right to collect late fees. That needs to be in your governing documents. Where I see mistakes being made is when you have a quarterly assessment, but you're charging $25 per month. Okay, you charge on each installment. Same thing with interest. It gets charged on the assessment installments. It doesn't get charged on the late fees. It doesn't get charged on attorney's fees or costs, which are automatically collectible, by the way, once that notice of late assessment expires. And I don't think we can go into more detail about that right now, unfortunately, but two important things that I will mention. Any payment the association receives needs to be applied in this method, this first bullet point. First to interest, then to late fees, then to costs and attorney's fees, and then to the delinquent assessment. So when you've got, $500 in late charges that have been accrued to an account and someone pays only the amount of the assessment, they did not pay in full for the assessment. They paid an amount that gets credited in this order of importance. And they still owe whatever is left in total of the assessment. So that's why you can continue charging interest on that unpaid portion of the assessments. Restrictive endorsements are basically, well, this is payment in full, but it's payment of one assessment and you owe 50. No, sorry, Florida law says that doesn't mean anything. So if someone writes something on their check or on their payment or sends a letter with it that says, I'll consider this paid in full and you guys need to leave me alone, your answer is, no, I don't. You're wrong. And it doesn't work that way under Florida law. So these are some of the notices that go out, and I'll be very brief. Notice of late assessment, 30-day notice says you owe us a bunch of money, and it's basically going to be sent by first-class U.S. mail, not certified. This is generally going to be sent by the association because you can't charge attorney's fees for it. So why have the attorney charge, a couple $100 to send out a letter that you can't recover those charges for? Now you've got two 45-day notices. One is the intent to lien, one is the intent to foreclose. The first one comes right after the notice of late assessment. It basically gives 45 days. It's sent certified mail, preferably by counsel or management. And it says, here are the amounts you owe. If you don't pay within 45 days, we're going to record a lien against your property. The lien then gets recorded if the owner doesn't pay in full. If they make a partial payment, you send a payoff letter. If they don't pay pursuant to that payoff, you just move forward and reduce the amounts that are included in the lien. And the next notice, which is a notice of intent to foreclose. Okay, again, I'm going fast. One, because of time, and two, because we've got an entire class on this for an hour, and you should be watching that rather than getting all of your information in a class that we just don't have the time to go through everything. This could be a 12-hour class easily. So I'm going to go a little fast. Then we go through a foreclosure action. This is the same as any other lawsuit. You serve the owner with a copy. If they don't respond, they get defaulted. If they respond, we deal with the response. And then eventually, if we prevail, we get a judgment. Now, the difference is that judgment is also going to establish a sale date for the property is going to be auctioned off. That auction might be at the courthouse in person. It might be online. It's basically like eBay if it's done online. Okay, that's an oversimplification, but bottom line, once that sale happens, either the association ends up with the property, which is not the goal of the foreclosure sale and is not the goal of a foreclosure. The goal of that is to get paid. And as a result, if someone is willing to bid more than the association is owed, then that person gets the property and the association's paid in full. Okay, so moving on, we've got safe harbor issues. This is the limitations that there will be on what someone owes after a lender forecloses. That's something that you'll want to deal with individually with your attorney, but we've got the slide here explaining what happens in that case. If there is a master association that forecloses, there's also different law that applies. I won't go through this in detail, but if the association takes title, there are certain amounts that may or may not be eliminated depending on who takes title first. Third-party bidders, you'll have to have your attorney take a look at your governing documents to see what they owe, if anything. The thing to keep in mind is after that mortgage foreclosure sale, no one is going to owe the interest, late fees, attorney's fees, or costs that were incurred against the prior foreclosed owner unless the lender failed to name the association in the foreclosure action. Moving forward, there are things that we can do to move the lender's case forward if the association wants, so that can be helpful. You can also send a rent demand, regardless of what else is going on. This is a notice that's statutory, and it basically says, hey, tenant, you've got the obligation to pay the association all of your rent until this account is brought current. We're not going to give them a dollar figure. We're not going to give them a specific time frame to pay other than the 14 days that's provided in the statute. And if they don't provide the payment or notice that they have already paid their rent for that month to their landlord within that 14 days, then technically the association can evict that individual from the property. Now, that presumes that there's actually a lease. If this is a family member living there, the obligation to pay money doesn't suddenly get created just because there's someone other than the owner living there. So keep in mind, it's only what they would normally pay their landlord under their lease. Receivers are something you want to avoid, but this is in the context of an abandoned home. I've never seen someone actually use a receiver for an abandoned lot. Usually the association just goes ahead and forecloses and then decides what to do with the property. Financial reporting is our next topic, and we do have, I believe, a class on this as well. So I'll kind of breeze through most of the rest of the materials so that we have time for Q&A, because I've got about 15 minutes to go through about 70 slides. the important thing to make sure you know is within 21 days after the financial report is completed, which needs to be done within 90 days after the end of the fiscal year. The association needs to actually produce that report or notify everyone that it's available within the community. Now, that can be up to 120 days if you're using an accountant or other professional to create those reports, and it takes them longer. So keep in mind, whatever the time frame is, it needs to be within 120 days, and it needs to be within 20 days after the financial report's completed or received from that third party. The level of financial reporting is going to depend on, frankly, what dollar figures your community brings in for the most part. It's the mo money, mo problems dilemma. Now, the other thing to keep in mind, the statute changed this year. Regardless of how many dollars you bring in, you will need an audit if you have at least 1,000 lots in your community. An audit is like the bad mamma jamma top level reporting requirement. You need to use a CPA. That CPA reviews literally every document of the association from the last time you had an audit performed, and it's really in depth. Whereas let's say you're at less than 150,000, the report of cash receipts and expenditures doesn't require any level of oversight whatsoever. It's basically, here's a spreadsheet of what we brought in and what we spent this year, categorized by what we spent or what we brought in. So you, depending on what level you're at, you may require a more detailed level of reporting, a more detailed level of analysis. So just keep in mind, look at this list to make sure that you're complying with these requirements. Now, you can vote to raise or reduce the reporting level. It's going to be a majority of the total voting interest if you want to change that. If you want to change the reporting level to go up or down, if 20% of the owners petition for a higher financial or a lower financial reporting level, you do need to hold a meeting of the members, not a board meeting, but a member meeting within 30 days after you get that to figure out whether you're going to do this or not. Again, a majority of the total voting interest, not just those people that show up, is what's required in order to change that level of financial reporting for that fiscal year. And I believe the change was also this year that you can't do that in more than one fiscal year in a row in consecutive years. So you would have to have, we do it this year to reduce or increase. We vote again, not next year, but the year after. Same thing here, lowering. You do have certain financial reporting disclosures if you don't have reserves, which is most HOAs in my experience. It basically says, hey, we don't have reserves, and as a result, if we need a bunch of money that is required upfront all of a sudden for deferred maintenance that's not done, every year, and this is once every 15 years, we're going to probably have to levy a special assessment. So just be prepared for that financially. That's basically what these two disclaimers say. Okay, contracts and bids. Contracts need to be in writing under Florida law. If it can't be fully performed within 1 year for the purchase or lease of materials or equipment, or if it's a service contract. All written contracts entered by the association should be in writing and should specify all of these things. Now, the bottom line, and I wrote this on LinkedIn the other day because I had it come up. If you have a $150,000 contract come up, and you're worried that your attorney is going to spend $3,000 to $5,000 creating an addendum or reviewing that contract and giving you notes on what needs to be changed to best protect the association, think about that. You're saying we won't spend $3,000 to $5,000 to avoid $150,000, possibly more, $1,000 in damage because we didn't have our attorney look at it. Please. Anything that's more than a couple $100, have your attorney spend the time to take a look at it. You might even have your attorney create a contract addendum form so that everything that can possibly be covered in that contract is covered. And you might have that one-time expense with limited questions as they come up later on. But at a minimum, make sure that your attorney has looked at something. Because if not, then you don't know whether there's an attorney's fee provision, which means that if you bring that contract to me later, I'm going to say, yeah, you can go after that $20,000, but it'll probably cost you between $10,000 and $20,000 to try and get a judgment that you then need to spend more money to try and collect. So it's things like that that aren't always in these contracts, especially when you have a potential vendor who just gives you an estimate that you're supposed to sign and they do the work. I have clients who have $100,000 estimates that they sign, no contract whatsoever. You're at complete risk at that point. So bottom line, just take the time, spend the money to have your attorney take a look at those. If the cost of that contract is more than 10% of the annual budget, including reserves, if you have any, the association needs to obtain competitive bids. Now, the lowest bid is not the one that you have to accept. You accept the one that you think will do the best job for your community. You don't need competitive bids in emergency circumstances. You don't need a bid if the person or the company is the only provider in your county. And for contracts that were executed before October 1st, 2004, and any renewals, you don't need to do competitive bidding. That doesn't mean you shouldn't. It means you're not legally required to. There are certain contracts, and they're mostly for professionals and employees, that don't require bidding. However, all those contracts do need to be in writing. Okay, so keep in mind, you do have exceptions from this bidding requirement. Take a look at the list here, take a look at the statute if you want, but all of these contracts do need to be in writing, and they should be reviewed by your attorney, except for the contract with the new attorney, which you could still have the attorney review. All right, bidding. If a contract was awarded under the competitive bid procedures, any renewal is not subject to competitive bids if the contract contains a provision that allows the association to cancel on 30 days notice. So that management contract that says you need to give 60 days notice still might need to be rebid. Now, management is not one of those is one of those exceptions where you don't need to bid, but keep in mind, I'm just saying any contract that says, yeah, you can terminate at the end of any year with 60 days notice is not good enough for this provision. If the declaration or bylaws provide for competitive bidding, you may operate under the provisions of that declaration and bylaws unless they are less strict and require less bidding than what the statute says. Communication services, which Heather, I don't know if you want to step in here as to, some of this stuff, but this is what Heather's company does. Bulk communication contracts are an operating expense. They're allocated on a per lot basis, even if the government's governing documents provide for something other than equal sharing. You can change that allocation, and then you can cancel the contract. Heather, you might want to close your ears. If the majority of the voting interest present at the next regular or special meeting of the members vote to cancel the contract. And at that point, only what has been spent and done by that vendor up through the time of the cancellation is to be paid to the vendor. Now, if that motion is not made and the vote is not obtained during the very next meeting after the contract is signed, I don't care if it's a 10, 15-year contract, it's going to be going through and it's deemed ratified for the term expressed in the contract. Okay, now there are certain restrictions for people who are hearing impaired or otherwise can't use the services being offered. They might not be required to pay for those services. That's something you'll want to run by your attorney. There might be other providers that other people want to use. That doesn't mean that they don't need to pay for the services that are already being offered. Transfer fees and estoppel certificates is part of the collection, and given the time, I'm going to breeze through this. Basically, an estoppel certificate is a document that says what needs to be done in order to bring this account current. That includes covenant enforcement violations, things of that nature, and it needs to be provided within 10 business days after you receive the request. Now, there are charges that you can send, but the general information that needs to be in here is in the statute. There are some companies, the title company is usually the one that's going to request this, that have their own form. If that's what they ask you to fill out, you can fill that out instead of just having your standard form, which I've created for some of our clients. Again, it's assessment information, other information, things that are coming up while that estoppel is valid. Now, it's good for 30 days, and you can charge these rates that are listed in this slide if you have a resolution that says you can charge them, or the management contract says that management will charge them either to the owners or to the association. If you don't provide it within the 10 business days, you cannot charge any fees for preparing this, even if you're paying your attorney, because there isn't a delinquency and the account is with your counsel. You do need to send the money back if the closing doesn't occur, but that money that you have charged, so let's say it's $1,000 between all the fees I mentioned on the prior slide, you send the money back to the person that paid them, but that gets added as an assessment against the individual lot. So that money doesn't just go away. You don't lose it. You did the work. You're entitled to it, but it's the owner and the lot that actually owe it now instead of the person that paid it. That's going to be good for 30 days if sent by email or fax or hand delivery. If it's sent by mail, which I don't know anyone that's sending them that way, but it'll be good for 35 days. You can amend it while it's still valid, but you would need to prepare the new one to be good for yet another 30 or 35 days as applicable from the date that that new amended estoppel is issued. You waive the right to collect anything that is not included there. So if you've got violations that aren't listed, you might not be able to enforce them against the new owner if they're not listed on the estoppel. So be very careful to make sure that everything that's listed on that estoppel certificate is accurate and that it includes everything you need done. If it's not accurate, I have had people say, well, you held up my sale and I'm going to sue you because I ended up not being able to close because you screwed it up. Now, keep in mind, whether they win or lose, there is an entitlement to attorney's fees and costs in that type of lawsuit. So just be careful, make sure to get it done in time, make sure to get it right. There is the potential for requests for other information. You can charge $150 plus the reasonable cost of photocopying and attorney's fees incurred if, let's say, the lender or someone else is requesting additional information that's not included in the estoppel certificate form that the statute has created. Covenant enforcement, again, this is literally, I wrote the book on collection and covenant enforcement for HOAs that's pending publication by the Florida Bar. We have a class on covenant enforcement that I would recommend you watch because frankly, we don't have time if I want to get to any Q&A to go through a lot of this, but we've already gone through some of it with respect to the things that I said. I'm not so sure that's a constitutional issue or not with the legislation that's changed this year. But covenant enforcement is basically telling someone you have violated the restrictions and rules applicable to your lot or the community. These need to be enforceable rules. So you might want to have some, we literally just yesterday did a review of someone's entire set of rules and regulations to make sure that they were actually enforceable. And out of about 50 rules, we found 15 that were not enforceable. So just keep in mind, you might want to have your attorney take a look at those things to make sure that you actually have the support for it and that it's not going to get you in trouble with either the Fair Housing Act or other aspects of Florida or federal law, or that it's enforceable. There is the right to fine. My suggestion, if you have self-help rights, be careful with it, which is going onto someone's property and curing a violation. If it's just landscaping or something simple, great. Use that so you don't have to pay me to do that work. If not, then you might want to have a letter sent by your attorney if the individual ignored management's letters, and then have another letter that's called an offer for pre-suit mediation sent that says, if you don't fix this or agree to settle, we will be suing you in the next 20, 30 days. So these are all things I hate to skip through because it's very important from my perspective. But the reality is we just don't have the time right now to go through it all if you want to get to any Q&A. So I'm going to skip through a lot of this, and I do welcome everyone to go on our website at KBR Legal to review all of this information, which is included in our 1-hour covenant enforcement class. It's called Covenant Enforceability for HOAs and Condos. 90% of it is applicable to HOAs. So insurance, you need to have adequate insurance to cover the common areas and any association property that you're responsible to maintain. What is adequate is something that I would suggest that the board discuss or management discuss with your insurance agent, and make sure to get in writing that they are saying it's adequate to cover what you're required to do, so that if they screw it up and don't provide the coverage you need, maybe you can go after them. Flood insurance is very highly recommended. This is something that people, for some reason, still don't have, even though they've seen what happens every time there's a hurricane. It's the, oh, no, you weren't damaged by the wind, you were damaged by the floods. Well, my roof came off because of the wind, not the rain, but sure. Bottom line is, if you don't have that flood coverage, you might not be covered for any storm-related damage. So just make sure that that's something you're looking at. Directors and officers liability insurance, I think, is one of the most important bills you will pay throughout the year. That is the thing that, from my perspective, keeps people actually willing to serve on the board because they're covered by an insurance policy for the things that they do as directors and officers. Fidelity coverage is also required for anyone that has control over association funds. That's another thing you want to discuss with your insurance agent. Covered perils is basically what is actually covered under your insurance policy. So you want to make sure that if the insurance policy includes generic statutory references to explain covered perils, which is the words that are going to be used in the policy, chances are the policy is not really worth a whole lot with respect to those issues. So just make sure that you know what this policy actually covers. That's something that your attorney can review the policy in depth and confirm what does it cover, what does it not, what should be covered by the insurer. And if they deny a claim for something that should be covered, we can also, as a law firm, help out with basically pointing out why they're denying it in bad faith. Now, if you get sued, chances are you're going to want to go ahead and submit that as a claim to your insurance carrier so that the carrier will pay for your defense instead of you paying your law firm on an hourly rate. You would basically just pay your insurance deductible. Now, if it's a claim for $4,000, yeah, that probably is something you'll want your attorney to address initially. If it's a claim that exceeds your deductible, I will almost always say you should be submitting that to your insurance carrier. There are issues involved in insurance that you should know about. The Fair Housing Act, basically, if someone has a disability and needs something to accommodate and allow them fair use and the equal use of your facilities, of the community, of their lot, etc., you probably will need to grant that accommodation. That includes these emotional support animals, service animals. This is another one we have an entire class on. So I'm going to go ahead and skip through some of this. But the bottom line is you will want to know, is this a pet and is subject to our pet restrictions? Or is it one of these two types of animals? Again, having a written policy that outlines how to deal with these requests is something that will avoid the need to have you run these things by counsel every time they pop up. My perspective is 2 to 3 hours worth of attorney's fees one time is probably better than an hour or two of attorney's fees every time someone makes a request. So we're going to skip through all this, and I can go back to it to the extent we have time later. But I want to get to everyone's questions, and I know that 90% of the time we don't have enough time, even if it's a half hour's worth of additional time available. Recall is very important to understand, and it's important because once you get an actual recall petition, that needs to go to your attorney that day, because you only have 5 business days to decide whether you're going to certify the recall, meaning removing the person or persons that are listed on that recall petition, or you're going to say, nope, not good enough, sorry. You need to actually have a board meeting. So any director can be recalled and removed with or without cause. This is what I mentioned earlier. You don't need to have a reason for a recall. You don't need to state a reason for a recall. You need to get enough votes for a recall, and that's it. And the required number of votes is a majority of the total voting interests. You can do this 2 ways. One is by written agreement. You literally get ballots signed by the members individually that say, I want to remove these people from the board or this person from the board. They can say, I want to replace that individual with these other individuals or these individuals with those other individuals. It doesn't have to be if it's less than a majority of the board. The other option is if you get at least 10% of the voting interest giving notice of that meeting, meaning you've got 10% of the members signing a petition saying we want to at least have a meeting to vote to try and get that 50% number or majority number, then you would have to have that meeting. Now, if the board doesn't hold the meeting, the members are actually able to call that meeting. Okay, it's not that they're saying we want a meeting, they're actually calling it if it's by meeting. Now, they can alternatively say we want you to hold that meeting, and that would just be a regular special meeting held for the purposes of having a recall. So it would be done the same way, but just understand there is a distinction there between scheduling the meeting as members and having the board forced to schedule the meeting. Again, within 5 business days, the board must notice and hold that meeting to determine whether or not these people come off the board. That's why it's so important that you get this to us right away, because let's say, for example, in one of the communities that we represent, it's over 3,000 lots, half of the members voting would be, what, 2,000 almost? We have to review every single one of those ballots to determine whether it's valid until we get to that majority number. So keep in mind, this is something, and keep in mind also, you have 5 business days to hold the meeting. So, that means that sometimes my entire staff in my office is doing nothing but reviewing these records until that meeting occurs to make sure that we get it right. So bottom line, get it to your attorney the second that you get served with a recall petition. The meeting minutes must state the time and date of the meeting, the decision of the board, and include a vote taken for each board member sought to be recalled. If the recall is certified, meaning the person's off, the recall is effective immediately, and the person who is now off the board needs to return everything of the association within their possession within 5 business days. If the board decides not to certify the recall, the board must file a petition for binding arbitration with the division, which is a state entity that will handle the arbitration and the division rules, or file an action with a court of competent jurisdiction. So you've got 5 days after that, 5 business days after that meeting, meaning 10 business days from the date that you receive this to actually, maximum 10 business days to actually file a petition or a lawsuit. So this is why I say get this to your attorney right away. If you don't have the meeting, the recall is considered effective immediately after the expiration of the 5th business day. So keep in mind, this is potentially largely problematic. And then if the board doesn't notice the meeting or file the petition, the owner can file a petition or file an action in court. Now, keep in mind, it must be filed within 60 days after the expiration of that 5 business day period. The division and any court should not consider the recall if it's within 60 days before or after an election. The reason for that is because what's the point if there's less than 60 days before the election? And if it's within 60 days after the election, they need to challenge the election process rather than have a recall. Filling vacancies, if it's less than a majority, the vacancy gets filled by the affirmative vote of a majority of the remaining directors. If it's a majority or more of the directors are removed, the vacancies need to be filled by the members when voting on the recall. And so what that means is you don't want to let it be where, and I have someone that's trying to do this improperly now in one of the communities we represent, that you are trying to remove everyone from the board without any proposal to replace them with anyone. And they're trying to do it by petition. And you can't do that because then you've got no board. You've got no ability to operate the business, and you need a receiver and to pay someone who might not be an attorney's rate to basically maintain and operate the community, which you are paying nothing other than the management expenses right now to do because the directors are volunteers. So you don't want that to happen. You don't want to be paying someone like me to operate your community and charge my regular hourly rate to do so, and then also be required to do that until a court says otherwise. Turnover is basically the transfer of control from the developer to one or more directors. This is going to happen partially when at least 50% of the lots in all phases of the community have been sold. That's one director is selected from among the members. So the rest of the directors at that point are still developer appointed. Now, there are a couple things that will require the turnover. If you haven't already had this happen, you're going to want to take a close look at this slide. But since we've only got less than 25 minutes left, I'm going to go ahead and kind of push through this. But turnover is a very important process that the members of the board and frankly, the members should really understand well, because a lot of developers do not turn over until way after this should have happened. And some want to turn over right away, and that's fine. But keep in mind, there are certain things that the developer is required to do before that turnover happens and after that turnover happens. So the developer is entitled to elect at least one director as long as they have at least 5% of the lots in all phases of the community that they're still offering for sale in the ordinary course of business. If they have 5 lots, they're not putting them up on the market and they're just kind of sitting on them. That's not going to apply anymore, and they are not going to be allowed to have that one director on the board anymore. After they give control up, the developer can exercise the right to vote on any voting interests they still own, just like any other member, except for purposes of them buying up and reacquiring control of the association or selecting a majority of the members of the board. And then within 90 days after turnover, there's a bunch of documents that need to be transferred to the association, which is the list here. And that includes a full audit of the financial records and all the other stuff. Let's see. I think that's it. So now we can move on to the Q&A. And if we have time later, I will jump back into some of the stuff that we had to kind of skip through because I just wanted to provide that opportunity for everyone to kind of see what's going on and answer or get any questions answered rather than, take the time and take it up with stuff that we already have classes recorded for.
Excellent. Thank you.
That's a lot of words to say, Jeff. It's all you.
not too much. A lot of the questions were also addressed by Heather throughout, if they didn't teeter too much on legal issues. So there's a few of them in there. While you're going through that, folks, I want to please listen up now. I'm about to mention some important things. So if you are multitasking, please listen up. We placed the link into the chat area. Okay. If you don't see the chat area, hit the button right now just so it shows up. Okay. I'll place the link in there again. Going to do that right. I'm going to count to 5 and do it again, but you have to have it open or it won't show up. So hit the chat button just so it appears. Even if it says it's not working for you, we can send stuff your way. So I just placed the link in there a second time. Please click on that. And when you click on that, it's going to take you here. Okay. It's going to take you to the evaluation page. You go ahead and fill this thing out. And it's not as daunting as it appears. Just a lot of dots to pick, including whether you would like some contact from Alan and the firm or from Heather over at Hotwire Fission. So those are questions 3A and 3B. And then after you hit the submit button, your confirmation screen is going to look something like, will look exactly like this. Smaller if you're on a phone, of course. Once you click on it, submit it. This has the email information for Heather and for Alan, the website for Hotwire. And this fourth bullet, many of you were asking, where can I get the slides? This is where you get the slides. Okay, when you click on those, it'll open up depending on your browser. Okay, I'm using Chrome, but I'm also somebody who updates my browser on a regular basis. So if you haven't updated in a while, it'll be up to you to find out where the download and save buttons are. But a trick that always works, if you right click on the first slide, you can then save as or print that way. I'll go over that again more slowly after the Q&A, but also keep in mind that the certificates will be emailed to you using the email that you entered when you registered. So that'll take place over the next couple of days. The recording will be on kbrlegal.com again within a couple of days. So being that we said we're going to email you the certificates, be sure to keep tabs on your spam folders, your junk folders, and alternate tabs in your inbox. Last thing I'll say, Alan, I'm so sorry. For example, with Google, with Gmail, even the inbox has different tabs at the top, promotions and a couple other different ones. Sometimes these emails end up in there. Okay, so be sure to keep tabs on all of your email inboxes and tabs. Again, I'll do this more slowly in a moment. Heather and Alan, back to you both.
All right. So I guess we've got a bunch of questions. Looks like we've still got, only 8 open. That's surprising, but kind of a welcome change. Heather, thank you for helping me kind of clear these out throughout the program. That makes it a little easier. Now I see why I was
You're welcome.
taking longer than I'm used to and starting to scramble towards the end, because you did a great job of clearing these out during. Okay, so Judith asks, if a sale was closed before July 1st, 2024, and it was agreed a pickup truck can't be parked in a driveway, does that statute override it? Well, I mean, that's a completely different situation. It sounds from Judith's question like there was a separate written agreement that says that the pickup truck can't be parked in the driveway. If there was a separate agreement, the statute doesn't override the agreement. It would only override what's in the governing documents, at least this particular statute. So if you're talking about what's in the governing documents, whether the statute overrides it depends on the factors that we mentioned earlier. Does your declaration have that Kaufman language that says that the statutes as amended from time to time will apply to all situations or this particular situation? If the answer is no, you probably still have a basis to challenge that. You'll want to run that by your attorney. But the bottom line is, if you have a separate agreement with the current owner, whereby you agreed or they agreed that they wouldn't park the pickup truck in the driveway, that's game over from my perspective. The statute simply doesn't apply to that situation because it's a separate agreement. It's not an association covenant unless you recorded it as a covenant that applies to the whole community. But this sounds like it's a covenant involving one lot, even if it was recorded. And it probably was just some kind of email that they signed off on or something like that based on what you've described. So Judith, I hope that answers your question. Garrett asks, we're currently controlled by the developer and our HOA doesn't own any land or anything of value. In our last budget meeting, the membership questioned why we have over $1 million in reserves. Since I'm the only homeowner board member, how do we support having such a large amount in reserves? Well, step one would be to figure out what are the reserve components that you've got. I mean, what are you putting money aside for? Do you have almost nothing that the association controls, but you've got obligations to fix some roof somewhere? And I keep using the example of a roof, but the reality is maybe that's a reserve for the pavement in your entire community, even though you don't own anything else. Paving is not a cheap job. So I know, some communities, that's over $1 million job to repave the community. So it really just depends. What I would suggest is you're a director, according to what you're saying, take a look at the official records and figure out from either the budget or whatever other documents might exist, what are the reserves actually accounting for? What's the line item that this reserve is for? Or are we just putting money aside? Is it an official reserve? It sounds like the developer has established one, and that's great, but what is this money actually intended for? I think the answer to that question is really what's going to answer why so much is being put away. It's absolutely feasible that there's no reason to put that money away based on what you're saying. But it's also feasible that you just weren't aware that there is an asset that you didn't know the association owns, and that's what the money is being put away for. So again, I would suggest taking a look at the official records of the association and figuring out what is actually included in this $1 million, what's covered by it. Steven asks, can you make a rule in your 720 association that's not part of the rules of 720? Yeah, absolutely. I mean, that's what rules and regulations are all about. They just have to not conflict with your other governing documents and be supported by the governing documents, but you can create any rule that doesn't violate the governing documents or Florida or federal law. So the short answer is absolutely yes, you can. Judith asks, if a homeowner issue goes to pre-suit mediation and the house is then sold, can the association recoup attorney's fees as part of the closing sale documents? The answer to that is going to depend what's in your governing documents. Do they say that the association is entitled to recover attorney's fees and costs regardless of whether a lawsuit is filed? If the answer is yes, then yeah, you might have that right to recovery. The other question is, do they say that they're recoverable as an assessment against the lot? Because technically you've got a right to recover that money from the owner who's selling their lot, not necessarily from the lot itself, unless you've got the right to levy an assessment against that lot for the unpaid fees and costs. That's one of the amendments that I frequently work on for community associations, is changing it from if we win a lawsuit, we get our money back, which your answer would be no in that instance, if that's what's in your governing documents. Changing it from that to we are entitled to recover the fees and costs regardless of whether a lawsuit's filed, and as an assessment against the individual lot that caused us to incur those fees and costs, either once the violation is cured or once we get a judgment that says we were right and we win as the prevailing party. So I think that's the answer there. Garrett asked, how do we force the developer to hold a meeting to elect the other two homeowners to the board? When I was elected, it took 7 months after reaching 50% to get them to hold a meeting just for me to be elected. You send a demand. I hate to be blunt, but you send a letter saying, here's the reasons that I think you need to do this. You need to do it. Now do it. And if they don't, then you might need to, frankly, despite the fact that you're on the board, potentially force them to do it through any kind of litigation or petition with the DVPR. Let's see. Daniel asks, can you talk more about special assessments that may not need the 2/3 vote, but a simple majority of the board vote? For example, we have a structure that's no longer insurable at the level of the documents required. The fear is that 2/3 won't be achieved. Can this be a board vote to adopt the special assessment? And my answer is, I'd need to look at your specific documents to answer the question. But the general answer, which you should not take as legal advice, is yes, probably, based on Florida case law that says that the board has an obligation to do what the governing documents require. And if that requires a special assessment, you might have the authority and the obligation to levy that special assessment to be able to fund this thing. Now, when you say the 2/3 vote, I'm presuming that 2/3 vote is what your declaration requires of the members to actually levy an assessment. There's no requirement that 2/3 of the board vote in favor of a special assessment. That 2/3 of the board was the remaining members if there's a conflict after removing the person that has the conflict from the vote. Michael asks, seems people are buying certificates online for service and emotional support animals. How do we control actual from online purchase certificates? The answer is you do your own investigation. figure out, and having that policy that I mentioned will kind of guide you through that process, figuring out, okay, was this bought online? Did this person actually do any kind of meeting with the person? There are certain fair housing rulings by the Department of Housing and Urban Development of the United States that basically say, well, if all that's there is a document that says I certify, and it doesn't say I ever met with the person, I ever actually communicated with them, or if it says, yes, I met and communicated with them once via Zoom, and that's the basis for my analysis, unless that's an open and obvious condition that that person is able to diagnose during that one 15, 20-minute meeting, that might not be enough. So what I would suggest is run that by your attorney as to, one, preparing that policy that might outline how you should be dealing with this issue, and two, might kind of guide you through this particular situation, which is a little bit more complicated than most, even though it's commonplace. Robert asks, in updating our documents, why would one purposely exclude Kaufman language? Well, look at what the legislature's done over the last 3 years to say associations don't have the right to do what they've been able to do. In some instances, I mean, we've got communities that we represent that are over 50 years old. They've been able to do certain things for those entire 50 years, and now all of a sudden the legislature says they can't. If they had Kaufman language or amended to include Kaufman language, the statute would now apply and they wouldn't be able to do those things anymore that they've spent 50 years enforcing. So that's one reason that you might consider not including Kaufman language. I mean, yes, it's great if all you have to do is look at the statute and you've got the answer. That might save you a little bit on legal fees, but it's certainly not going to be easier when the legislature says HOAs are never allowed to do anything at all. Not that I think that's actually going to happen, but that's kind of the direction that they're heading from what I can see over the last few years. Why would you want to allow the legislature to control your contractual arrangement with your members? That's my answer. Okay. Ryan, looks like a technical issue. Sorry. Angelo, there was a bullet point that indicated about a president voting in a meeting and he skipped over. Well, I'm he, and I did skip over it because the president doesn't get to vote as president. The president is an officer role. Directors, not officers, get to vote. So when someone says the board president, doesn't exist. The president is an officer role. So the president as an officer doesn't get to vote. That might be the same person as one of the directors. So they get to vote as a director, but they don't get to vote as president, is what that says, which is why I skipped through it. Let's see. Rob asks, is there a cap on the amount that can be collected for unpaid HOA dues from a homeowner, and what is the best way to enforce the payment of these dues? Well, there's no cap on what you can collect, but there's a cap on the time frame you can collect for. So you can only collect up to 5 years of unpaid assessments. That's Florida statutes regarding the statute of limitations on a debt. So that's 5 years. There's no dollar value that caps that. What's the best way to enforce payment of these dues? Have a written policy that says you are automatically going to move forward in this collection process, regardless of what an owner might say or do, unless they are agreeing to pay you. So, you start with, let's say, 60 to 90 days after the account is delinquent, you send your first notice. That could be the notice of late assessment or some courtesy notice from management. And without having to go back to the board, management has the authority to say, all right, well, notice of late assessment expired. This is going over to our attorney to address from here on. And then the attorney has the blanket authority to make most of the decisions unless it's for settlement purposes or something of that nature. So you're basically saying, let's streamline this. Let's avoid having that 5-year delinquency ever come up so that we don't have to write off assessments that this person should have been paying and the rest of the members of the community have been covering all along. Judy, please explain when a board can meet amongst themselves only. Well, they can't unless they're discussing employment issues. That's the only exception. Or when they're not discussing association business, they can meet separately. That's easy. Judy, if the members of the board, at least a quorum, are meeting, whether it's via Zoom, phone, anything other than email, and they are discussing association business, that's a board meeting. It needs to be open to the members unless there is an exception. Now, a closed meeting needs to be with an attorney, so that wouldn't work in your scenario, but an employment discussion could work. under your scenario. So next question, Doug, if they remove the structure under an emergency declaration, they just need a board vote, correct? I don't know what structure you're talking about, so I can't really answer that. Holly and Michael, thank you. Daniel, thank you. Brian, thank you very much. Good to see you. Angelo, our docs say we can have no less than 3, but not more than 7 members. My question is, would you recommend a 6-member board? Absolutely not. I don't ever want an even number of directors. What I want to have is an odd number of directors that's between 3 and 7 in that circumstance. And the reason for that is you don't want to basically invite a deadlock on any issue. You want to have the board able to make decisions even if everyone doesn't agree. It would be great if every decision was unanimous, but that's not the way the world works. So I would say no to 6, but yes to 3, 5, or 7. And the way to change that, unless the governing documents specify that you need a member vote to change that number, which I think would be absurd, the way that you change it is you just have a board vote, and the directors who are then on the board get to decide how many people within that range of 3 to 7 are now on the board. Let's see. Should the treasurer be a check signer on behalf of the board? Depends whether you've got a licensed manager working for you. If so, then yes. Some communities that want to protect themselves a little bit more will also require that there be the signature of another officer or director along with the treasurer. That's really up to you. Susanna asks, if a homeowner is suing our association for falling on clubhouse property, do we need to disclose that information to all homeowners if our insurance goes up? I'm trying to think of an instance where you would need to. I mean, it's going to be part of your official records because any record pertaining to that lawsuit is going to be something that automatically is going to be disclosed. It's going to be a matter of public record because the documents that are filed in that lawsuit go up on the court's website, but it's not something you need to give some kind of special notice to the members. If anyone asks, why did our insurance costs go up? There's nothing wrong with mentioning we're involved in a lawsuit filed by a homeowner. But there's nothing that necessarily says, that you need to send a separate notice saying, hi, everyone, we've been sued. Have a nice day. So Doug, Doug, why don't you contact me offline? Because I'm still having a little bit of difficulty understanding what the question is. Feel free to email me as@kbrlegal.com. We've got about 5 minutes left, so I'll try and take a couple more. Tim asks, our declaration states we can't increase assessments more than 5% without a member vote. If they vote against it, what can we do? Use fiduciary responsibility to blow through the 5% or call for a special assessment that would cover the shortfall caused by insurance overages. Frankly, my suggestion is violate the declaration. Some really bad legal advice intentionally. And let the members come back and say, well, you know what? That was in violation of the declaration, so you need to reduce this. Your response is, okay, we were complying with our fiduciary responsibility, which is maybe more important than this provision in the declaration that shouldn't really apply and we should really be amending out. But let them come up with an alternative budget that won't meet that fiduciary duty, but it's not your fault as a director that the members got it wrong because they voted for a different one. That's my suggestion. Judith, if a president is an officer, not a director, can they propose a motion to be voted on? Only as a director and not as an officer. Michael, thank you very much. I'll look forward to working with you. Nice comment. Lawrence, if existing board members are meeting with new members to provide a new board member orientation touring the community, would you consider this a board meeting? Only if there is a discussion about association business that is part of that meeting. Now, the other way around this is to have only one board member give that tour instead of having a quorum of the directors meeting together. John asks, are ARC meetings required to be open to members, or can the committee have a meeting of their own? It's only open if the association the ARC is making decisions to approve or deny those requests. So it's just an ARC meeting to kind of walk through the criteria or something like that would be applicable, and you're not actually making decisions, then that doesn't need to be open to the members. Leslie, how often should the accounting records be audited? Whenever your governing documents say so. If you want to have one done every 5 years, have at it. But unless your dollar figures or the size of your community require it, again, that's going to be that you take in more than 500 grand a year, or you have 1,000 or more lots in your community, You wouldn't ever legally need to do it other than the developer would need to do it. Not able to pull up the survey. I believe that the chat might include, yep.
Yeah, I emailed him already and he figured it out.
Okay, well, I think that's all we've got, and we've got 2 minutes left to hit 2 o'clock. So I think we're done. I want to thank everyone, especially Heather and Hotwire, for having us today. I want to thank everyone. We've got over 150 people that are still on and cared enough about what we had to say, even after they were already going to be given their credits. And I won't mention that Jeff didn't post the link until 1:38, and I'll just presume that they wanted to hear my voice and see your faces. So again, thank you everyone for coming. Thank you again to Heather and Hotwire. If you want to reach me again, as@kbrlegal.com, or find me under my name on LinkedIn. And that's all I got.
Wonderful.
Alan, I appreciate it as usual. Great presentation. And then if anyone has any questions for me regarding telecom services, or even a general HOA question that you think I might be able to help with, I'm happy to do that. And I know that some information on how to contact me was provided. You can also go to our website at hotwirecommunications.com under Central Florida, and you'll see me there to be able to contact me. So thanks, everyone.